Welcome to the 49th meeting of the Civil Rights Council, formerly known as the Fair Employment and Housing Council. The meeting is being called to order. Rachel Langston, our colleague, Senior Fair Employment and Housing Council, will conduct the roll call.
Chair Sandoval,
Present.
Councilmember Brodsky,
Present.
Councilmember Hong,
Present.
Councilmember Iglesias,
Present.
Councilmember Alude,
Present.
Councilmember Scher,
Present.
Councilmember Wilensky.
Present.
Great. Welcome, everyone. I would also like to thank all those stakeholders who are attending remotely. This meeting is being webcast live via Zoom video conference, and the video of this meeting will also be available afterwards on the Civil Rights Department website and the Civil Rights Department YouTube channel. Please subscribe. We also have closed caption available for participants, which you can find at the bottom of the Zoom bar features. If you're having difficulty accessing closed captioning, you can chat with the administrator to resolve the issue. Members of the public joining remotely may also have noticed that you're currently muted and your video is disabled at this time. However, please be advised that there will be opportunities for you to comment and participate throughout today's meeting as we address each of our agenda items. We have a number of ways for you to provide input and comments. For those who are planning to provide comment, you can email the council at fehcouncil@dfeh.caa.gov. Once again, fehcouncil@dfeh.ca.gov. We will be checking this email account throughout the meeting, and your comments will be read aloud and considered by the council members. Alternatively, you can also use the Zoom chat feature to send a message directly to the meeting administrator who can read your comment out loud. Or if you would like to speak directly rather than through your written text, please click raise hand in Zoom or press *9 if you have called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename in the list of options next to your name. Department staff members who will be joining us, and I would like to acknowledge at the beginning of this meeting, include Adam Romero, the Civil Rights Department's Deputy Director of Executive Programs, Becky Monroe, the Department's Deputy Director of Strategic Initiatives and External Affairs, Lily Harvey, Assistant Deputy Director of Education and Outreach, Rachel Langston, who you all have already met, Senior Fair Employment and Housing Council, as well as Mariel Block, Senior Fair Employment and Housing Council. Thank you to all those attending. We look forward to your participation throughout today's meeting. I also at this time would like to review the agenda. Copies of the agenda and meeting materials can be accessed at the council's page of the Civil Rights Department website. Highlight of today's meetings will include reports from Adam Romero, Deputy Director of Executive Programs, Becky Monroe, Deputy Director of Strategic Initiatives and External Affairs, Lily Harvey, Assistant Deputy Director of Education and Outreach, and Alec Watts, Assistant Deputy Director of Research and Strategic Initiatives. We'll also have consideration of proposed modified text of proposed modifications to employment regulations regarding criminal history, consideration of modified text of proposed modifications to employment regulations relating to religious creed discrimination and accommodations, and also consideration of proposed modifications to Fair Employment and Housing Act regulations, and then consideration of certain proposed changes without regulatory effect to FEHA regulations. We will also have updates from the council subcommittees. First order of business includes the approval of the minutes from our August 10th, 2022 meeting. I wanted to see if there are any comments or edits regarding the minutes from our council members. Okay. Seeing that there are no comments or edits, any public comment on this item?
There's no public comment on this item.
Thank you, Rachel. Can we have a motion to adopt the minutes?
I so move.
Second.
Great. Can we have a roll call, please?
Chair Sandoval,
Aye.
Councilmember Brodsky,
Aye.
Councilmember Hong,
Aye.
Councilmember Iglesias,
Aye.
Councilmember Alude,
Aye.
Councilmember Scher,
Aye.
Councilmember Wilensky.
Aye.
Great. Thank you, everyone. The next item on the agenda is reports from our council members. Do we have any reports from our council members? Okay, see none. We'll move to the next agenda item. We'll have the Civil Rights Department report. I believe Adam Romero and Lily Harvey will be presenting during this portion of the agenda.
Good afternoon, everyone. I'm pleased to introduce Lily Harvey, our new Assistant Deputy Director for Outreach and Education. I mentioned her back at our August meeting. She was just coming on board then, and so we've invited her to come here to introduce herself to you and talk about some of her initiatives. Lily, take it away, please.
Thanks. Hi, everyone. I'm really happy to be here with you all. Some of you I have met and some of you I haven't. So thanks, Adam, for having me come to speak with you. Just first, I know Adam introduced me a little bit before I joined. I actually stopped by the office to pick something up right when you were first meeting. So I may have seen you in the hallway. So he may have shared a little bit about my background, but I just wanted to give you a little bit of that before I get started sharing some of the exciting stuff that we're doing in outreach and education. I come to CRD with a background that has focused a lot in the intersection of civil systems and criminal systems. So specifically, I've done a lot of work in the criminal legal system as an attorney, post-conviction habeas attorney in California. I've done a lot of work in healthcare, particularly in prisons in California, and education in Washington state juvenile facilities. And prior to coming here, I was doing work at the intersection of housing policy and housing for people impacted by incarceration. So I bring a lot of intersectional interests and a lot of passion. I actually found out about this role because of some digging into the FIHA, and I realized there was a lot more having to do with criminal history in there than I had realized. So started talking to every housing provider and public housing authority and HUD staff person I possibly could, and it brought me here with all of you. So I'm really happy to be here, and I'm very excited to bring my background in programmatic design and strategic initiatives and getting stuff out to the public and engagement and outreach into my work here with our amazing outreach and education team. So just some quick updates on what we've been up to, at least in the time that I have been here. Some exciting stuff, I think. One thing is that we've been undertaking some real strategic planning work. So we've been looking a lot at who we have on staff and how to really help ourselves be as thoughtful. You know, I think during the COVID pandemic, there was such a all hands on deck moment, and everyone was trying to do as much as they could and in as many important places they could. And I think I'm so impressed with the work of my predecessor in all ways, the work that they did during a really, really challenging time and with Adam's leadership. But now we can't say we're in a post-COVID moment, but we're used to it a bit more moment. And so looking back now at sort of what the next chapter looks like and how we can take CRD's mission and the work of our small but mighty team to the next level in terms of how we're doing outreach, how we're engaging with people, and really trying to find pathways for it to get feedback and implement it in a meaningful way in the work that we're doing. So excited to talk to you more about that. I have had the pleasure of working with Gabriel and Helen as part of the Outreach and Education Subcommittee, and they'll share with you some more details. But just to give you a little preview, we're going to certainly be looking at opportunities to work with council members and to utilize your expertise, all of your great ideas, your time when you have it, and get a little bit more sort of interaction in terms of how the outreach and education unit makes use of your incredible skills, because we know you have a ton of them, and we want to put them to the best use we possibly can at all times. So more on that in a little while. And then I also just wanted to share, just since the last meeting in August, Apologies, I have things dinging. And since the last meeting in August, we have also published some new resources. So I'll go ahead and highlight a few of the biggies. We've updated our transgender rights and the workplace poster and an accompanying fact sheet. In collaboration with Becky and her team, we've expanded our hate violence fact sheet, and then we created new FAQs around that as well. And we've also done a new FAQ on non-disparagement and confidentiality clauses in employment, severance, and settlements and agreements. So those are up on our website now, and I don't know if I can drop the link or not, but they're up on our website under their appropriate tabs. So that's just a little bit of what we have going on. Again, we're really focusing on kind of regrouping and reflecting on what we've done and how much we've managed to accomplish thus far, and being really thoughtful about how we're moving together forward into the next sort of, 3.0 version of our outreach and education team. So I'm excited to be working with you all. Certainly know that, the regulations, once finalized, we'll look forward to collaborating closely on public education efforts on those new regs. And again, Helen and Gabriel will be sharing some more information a little bit later on about some of the nitty-gritty stuff that we're hoping to do with your support. So thank you again. It's a pleasure to be here with you. And I look forward actually to hearing the rest of the meeting.
Thank you, Lily. We look forward to continuing to work with you. As you mentioned, we have already had some good conversations about the work that you're charged with, and we'll provide more detail about that type of collaboration between the council and the department during our subcommittee discussion later on the agenda item. But once again, thank you so much for your presentation, and we look forward to working with you in a focused way on civil rights. Thank you so much. Any questions from council members regarding the report that was just provided? We have a welcome Lily from Councilmember Sure. Welcome. Okay, so let's go to the next agenda item. We have agenda item informational presentation, California versus Hate, resource line and network. We have Becky Monroe. So welcome, Becky, and we look forward to your presentation.
Thank you. And thank you for the opportunity to update the council on California versus Hate. First, I want to thank Gabriel and Dale, who are, I think you all know, lead the subcommittee on this, on combating hate. Since our last time that we talked, we have had a soft launch of California versus Hate. So and just to give you a little bit of background again, California versus Hate is our statewide resource line and network. The legislature gave us funding to create the state's first statewide hate crimes hotline, and after hearing a lot from advocates and working with people across the state, including law enforcement advocates, as well as other state agencies that are working in this space, wanted to make sure that we were responding to both incidents and crimes. So the three goals, again, of California versus Hate: one is to let people know what your options are if you are targeted for hate. You can call our resource line, or you can go on an online portal, and you can learn more about what your options are, and you can report if you choose to do so. Those options might include going to law enforcement. It may also include, if you don't feel safe doing so, just reporting to us in order to find access to other sources of support. The second goal of California versus Hate is to connect people with culturally competent resources and support. This piece, we know, is something that will continue to demand that we improve our access to resources that are indeed actually culturally competent. And so we are working a lot with advocates across the state to make sure we do that piece. And then the third piece is to improve our hate crimes data collection. Just to be very clear, when we're collecting data, we are talking about data that is reported by people who are targeted for hate or maybe who witnessed an act of hate. We are talking about capturing information about hate crimes, which are, it's a crime motivated by bias, or hate incidents. And when we talk about hate incidents, and I'm working with our sister agencies across the state to really get this message out, hate incidents can include civil rights violations, including Ralph Act violations. So an incident may not be a crime, but still a violation of law. And the other category that we want to talk about are incidents that maybe don't violate the civil or criminal law, but still cause significant harm in a community. So those are some of the things that we're trying to do through capturing this data. It is different than the data that law enforcement reports, for example, to the state AG's office, and then goes ultimately to the FBI. But we wanted people to understand, we think that by doing this, by recognizing that there are impacts of hate beyond what is reported to law enforcement, it will actually, in the long run, help to build trust, both with our state agency so that people can report civil violations of civil rights laws, as well as potentially build trust longer term in law enforcement. So we have had what we're calling the soft launch, that we are calling it the soft launch because we are able to provide the resources and support. We have contracted with 211 LA as well as a statewide network of 211s so that people can get access to resources and support, again, if they call or if they go through the portal. But it is a soft launch because we are waiting during this time. People can access the services now, but we are hearing back from advocates about, we need to shorten the intake form. We need to make sure, when we're saying things, we think things are accessible, that they may be language accessible, but not culturally accessible. So we're trying to make all of those improvements for our hard launch. Will come by the spring of the coming year, in which we will have a statewide media campaign that will be reaching, we hope, communities across the state. We are really kind of following the lead of, I think, what you're seeing from Lily and her work with leading the outreach and education team. This is intended to be community-centered. And what that means for us is that we are spending a lot of time reaching out to the community-based organizations that have earned the trust of communities who are targeted for hate. We recognize it doesn't matter how strong our services are if we have not yet earned the trust of the communities who are most likely to need our services. So we are trying to be a resource to those community-based organizations. So that's where we are. I'm really grateful to Gabriel and Dale. We've had, it's a great opportunity for us to sort of both, with respect to the council, think about sort of how does this all work? How does this work relate to our existing Ralph Act jurisdiction? And I think, Gabriel and Dale led an effort to sort of get feedback and help, potentially think about whether there's any kind of regulations that we need to do. We will continue to keep an ear out on that issue. We believe that when we're capturing this information that we're getting about hate incidents and hate crimes, we may learn more about that. And that we look forward to keeping you posted when we have the contract awarded for the statewide outreach campaign. So thank you for this opportunity. Any questions? Yes.
Is the 211 number active now?
You can call 211. Yes, it is. Now, one thing I want to be clear, and we learned a lot from our colleagues in Los Angeles. So the LA County, LA versus hate has been up and running for a couple of years. They continue to be tremendous partners. So I just wanted to say that, because if you are in LA, you can call, you've been able to call 211 for some time to get access to these resources and support. But now it is open statewide. So it's 833-8-NO-HATE is the other line that you can call, or you can go to the portal. We are encouraging, and through our state, when we get the statewide media and outreach plan up, we will encourage people to use 833-8-NO-HATE, because we have by contract a 3-minute, on average, there can be a wait that's no longer than 3 minutes, which, when we were looking at opportunities for us to sort of make sure we were providing these resources and support, the wait time was a concern. So we are going to share that number, and I can put it in the chat as well. Okay. And I will have, and like I said, this is a slow rollout, in part because we don't have the statewide campaign, but we are trying to make sure people know if they want to access resources and support, they can now. And we are going to continue. We also have an email address that I can share where we are specifically asking for what we're not doing right. What do you think we need to do better? What doesn't look right in terms of how we're capturing information now?
We have a question from Councilmember Tim Iglesias. Councilmember, go ahead. Thank you, Becky.
Sure.
Thank you very much. Thanks, Becky. This sounds wonderful. I really appreciate all the work. It sounds very exciting. And I can see you're kind of bridling because it's not yet going yet, but I get that. So my question is, I know during the prior work of the subcommittee, it was recognized that law enforcement is a key place where people think they should go.
Yes.
And that there had been a practice of not, if something didn't rise to a criminal level, there was a practice generally of just saying, go away, and nothing happening. And I'm curious what the response of law enforcement so far has been to your work in terms of them kind of beginning to fill in that gap.
Thank you, Commissioner. That's a great question. And you are absolutely right. That was a concern we had heard, and we've thus far, law enforcement has been very, very receptive to this. So essentially, what you were getting at as well when I was talking about hate crimes and hate incidents and why we need to respond to incidents, it's getting to that point, just that precisely that point. So what we have heard from law enforcement is that we are giving their officers options as well. So they don't have to be in the position of saying, this doesn't rise to the level of a crime and I can't do anything for you. They can say, this may not rise to the level of a crime, but I want to give you this resource, and these are different options. So when we talk about the statewide, campaign that we're developing, we're also going to be developing sort of both materials that are written as well as digital that law enforcement can point directly to and say, I understand this caused significant harm. Here are some options. You may have a civil claim, you may have, or even if they don't want to get to that level, they can at least have another option. So I would say, we've talked to POST, which is the Police Officer Standards and Training Office for the state. They are very interested in sort of the options for law enforcement. So in my past work, I've spent a lot of time working with the International Association of Chiefs of Police. I continue to work pretty closely with their Civil Rights Committee. And this is what I've been hearing as well from chiefs, not only in our state, but across the country, is that there's a real interest in a recognition by law enforcement that in many ways, an effective response to hate incidents and hate crimes is central to building trust. And one of the quickest ways you break that trust is if you don't provide any kind of response or options. So I say that, I just want to note that that is absolutely right. And what is also absolutely right is some communities may not feel safe going to law enforcement. And we are going to meet those communities where they are as well. We believe that part of this work will be to build that trust, but we are not going, part of why we were fortunate to have the resource line placed with us was because we are not connected to the criminal legal system. So I just want to put that in there as well. So we're trying to do both. And, and I think we've been given the opportunity to both sort of build that trust, but also recognize that people may not be there yet.
That's great. Thanks, Becky.
Sure.
Thank you. Councilmember Hong.
Thank you so much, Becky. I think this is incredible. It's going to be so exciting to see that data from a different lens, because so much of that criminal data is based on those FBI categories, which is really pejorative and it could be so questionable. My question is a little bit broader, because what I'm really excited about is, you're working with organizations that are generally not legal services. These are CBOs, they're on the ground, they're grassroots. It's a much different audience that I think most probably have never worked with DFEH or CRD, don't know these resources exist. So how have you seen, if at all, that opportunity for increased partnership? How does that overlay? Because your charge is so large, it's almost like you want to ask them something very narrow, but yet there's all this other resources that they may benefit from. So how are you balancing that? What are you seeing? And from my council standpoint, working with Lily, how do we kind of parlay that and maximize that? So my long-winded question.
Yeah, no, it's a wonderful question. And I'm grateful for it, in part because it allows me to sort of highlight, I think, what Lily has already done in her role and what Adam had been doing for some time. So, you are right. Traditionally, I think many people would think, oh, we don't have any of those relationships. But thanks to Lily and Adam, we did have a lot of those relationships. Stop API Hate knew us very well, for example. And that was through a lot of the work that Adam had done over the years to build that relationship. So some of those, but you're right, there are others who were sort of surprised to hear from us. So I was, I've been trying to work with, for example, National Action Network, NAACP, other smaller sort of social services providers that provide services to Asian Americans. We've been spending a lot more time more recently trying to reach out to Native American communities and to Native American organizations. So there's been a few ways that we've tried to address it. One is, to your point, I think, really thinking about, we have to approach this with some humility. So recognize we think we know what resources people need, but we don't know. So in terms of gaining entry, to your question about how we're accessing some of those social service agencies that have never heard of us, or maybe that haven't thought about working with us before, it's coming to them and saying, we know there are impacts around mental health. We know there are impacts around sort of health and social services. We have a sense from past experience of what people want. We have some great data from what from Councilmember Brodsky and Councilmember Sandoval, with the work they did when they had the sort of listening session, but we know we need more. So we've been making it clear that we are not only a reporting line, but we're also access to culturally competent resources and support. Another thing we're doing, which I think has been really helpful, is to say, we get that if you are a small NGO, a small community-based organization, even just committing to consulting with us once a quarter is tough. You have lots of things that you're on your, so we are developing relatively small contracts that we will use so that we can make sure we're actually compensating some of these NGOs for their time when they're providing us feedback about what's working and what's not working in terms of reaching the most vulnerable communities. So that's been helpful as well, as I think to sort of recognize that people's time is valuable. We also, to your point, in terms of data, we have a lot of work to do. And so we have been very careful about sort of making sure that we're very transparent about the failings of our current data collection system and what we're trying to do better. And then I do want to mention as well, we've been working very closely with the CDSS, the California Department of Social Services, as well as the state library. They have a Stop the Hate program that they have been, they have funding for as well. CDSS has given out grants to local community-based organizations across the state. And so, for example, all of those are now resources through the California versus Hate resource line and network. So we've been bringing them into the conversation. And then the state library has been funding ethnic media outlets with grants. They have been tremendous in getting the word out, not only about sort of the resources that are available, but in allowing us to get feedback from different communities who are targeted for hate. So I think that partnership has been really helpful as well. And then we've been working with the AG's office as well to make sure, as they do that, what they do in terms of data collection, what they do in terms of public outreach, that we're kind of collaborating with them to make sure that we're all sending out the same message. So I think you're highlighting an area that we know we're going to have to stay pretty laser focused on. You can, when I used to work a lot with local governments and law enforcement, we would say it takes a really long time to earn trust, and you can lose it really quickly. So we are committed to continuing to earn it and certainly to losing it.
Becky, I have a question for you. In what ways are you working with educational institutions? We know that unfortunately, sometimes issues of hate and hate incidents start in the school setting. And if it's not addressed, it could lead to different types of events. And so I wanted to see if you're also looking into that arena.
Absolutely. And actually the California Department of Education is also part of this interagency group that we've been working with. They have some grants that are going out about sort of curriculum that's intended to sort of help to combat hate. I think it's also really important to note, one of the things you're raising is that acts of hate that can happen in schools, some of them, people just use the term bullying. And I think sometimes people hear the term bullying and think there's not a violation of the law. There are forms of bullying that are in fact violations of civil rights law. Whether it's state law or federal law. So we also know from our partners at LA versus Hate that school-based issues are definitely one of the sort of biggest areas that they see. So we are working both through Department of Education, but also sort of thinking about ways that we can reach students through sort of more creative means. So for example, through the most we had a Unite Against Hate Week. There was a Unite Against Hate Week across the state. We were invited to participate with LA versus Hate in training law students who are preparing to kind of provide some trainings for students in high schools about what are your rights? What are your rights for your elders? What can you do? So almost like many of you may be familiar with street law. So sort of similar to that, but focused on hate crimes. So that's a sort of one small way that we're thinking about it, but we are absolutely, you've hit on a really key issue. And I think as we think about prevention as well, you've got to think about what we're doing in schools. And I have to say that we also want to make sure people know that acts of hate that happen in school, even if they're not a crime, they very well may violate civil rights laws. We want to make sure people are aware of those requirements for schools as well.
Thank you. Do we have any other comments or questions from council members? Okay. Thank you again, Becky, for all the work you've done over the last several months. And I know it's a tall order, so thank you for your focus on this issue.
Well, thank you.
All right, so we're going to move on to the next.
Chair, I think we do have a public comment.
Oh, good.
Okay. Bruce Wolf, he entered his comment in the questions and answers, and I'll just read it briefly for the record. If it, and I believe it refers to a hate incident, because that was when the question was sent in, when that was being talked about. If it is against the law but not a crime, then how is it classified and enforced? And Chair Sandoval responded, it can potentially rise to the level of a civil rights violation under state law, for example, under the Ralph Act. And I believe that was the only public comment.
Would you like to add anything else, Becky, to that response?
No, that's absolutely right. And I think, Lily and Adam and their team worked with us to recently update our hate violence fact sheet. And so I would really encourage people to see that. The Ralph Act is a protection that we would like to see more people sort of aware of in terms of their rights. So that is one way in which it could be accounted for. The only thing I will say is that if you're looking at sort of the hate crimes data that comes out of, for example, the Attorney General's report or the FBI, it will not be reported there. It will not, that's not what that is intended to cover. We intend to address that through California versus hate.
Thank you. No further public comment, Rachel?
No further public comment.
Thank you. Okay, we're gonna move to the next item on the agenda. We have a new colleague, Alec Watts, joining us, Assistant Deputy Director of Research and Strategic Initiatives of the Civil Rights Department. If you could take a few moments to introduce yourself, Alec, and then provide your report, we would be appreciative. Thank you so much.
All right, thank you. Good to see all of you and good to meet some of you. My name is Alec Watts. I'm Assistant Deputy Director of Research and Strategic Initiatives at CRD. I just started in October. Most recently, I'm coming from the Assembly. I worked for a year in the Assembly Judiciary Committee. Before that, I was doing research. So I was in tech for a few years doing product development research. Before that, I was in academia. So I received my PhD in sociology, where I studied the psychology of prejudice and discrimination. So anyway, I'm using those range of experiences to advise the newly established Commission on the State of Hate, which I will discuss with you now. So give me 1 minute. I will share my screen with you and show some slides. Can everyone see that okay? We're good? Okay,
yes.
Cool. Okay, thank you for the opportunity to talk to you today. So the Commission on the State of Hate has been several years in the making. It was established by AB 1126, authored by Assemblymember Bloom. That bill was introduced in February of 2021, made its way through the legislature, was signed last year in October by Governor Newsom. We just received funding for the commission this year, and the first meeting of the commission just took place December 1st, so a couple of weeks ago almost. So I just want to talk to you a little bit about what the duties of the commission are and what the requirements are in AB 1126 that established the commission. So the mission of the commission is to strengthen California's efforts to stop hate through three main strategic areas. So one of those areas is research, the other is education, and the third is advisement. And advising to help communities and government officials both monitor, but also prevent and respond to hate activity. And I'll talk through a little bit about what this looks like. So if we break down the duties and the goals of the commission into these three areas, one area of the commission, one focus area is this research kind of pillar of activities. So AB 1126 requires the commission to engage in fact-finding, data collection, and research with subject matter experts. Many of the commissioners are subject matter experts themselves, of course. They're also charged with publishing an annual report that will include a comprehensive accounting of hate crime activity in the state, provide recommendations for law enforcement, the governor, the legislature, and communities on how to reduce and respond to hate crimes, and also identify best practices that we've seen be successful in other jurisdictions and recommend they be implemented statewide. The first report of the commission is due July 1st, 2023, and then annually after that. The second kind of class of activities of the commission are related to education and outreach. So the commission is required to host 4 community forums on the state of hate per year. These forums are required to focus on local, state, and national evolving trends related to the state of hate, and also include presentations from subject matter experts. The third pillar of activities is related to advising different bodies within the state. So the commission is charged with advising the legislature, the governor, and state agencies on policy recommendations related to promoting mutual respect among California's diverse population. They're also charged with suggesting recommended training for state officials and staff, and also advise on other matters periodically. The commission is also required to provide resources and assistance to the public, the DOJ, the AG, the Office of Emergency Services, and law enforcement agencies. So that's kind of in the abstract what AB 1126 requires of the commission. Now, of course, with the council, I think there's some opportunities for collaboration, and the work is just getting off the ground. So we don't have a lot of tangible things to report on just yet. But if we think forward to what the commission is charged with, I kind of highlighted some areas that you all might identify as opportunities for collaboration, and we can think through what that would look like later on. But just to let you know, we're just getting started. So on the research side, I think there's a lot of requirements in the bill to collaborate with different experts. You all are experts, and I'm sure there's opportunities to collaborate with you on the report or even designing some of this research. Also identifying best practices that we've seen be successful elsewhere. I'm sure many of you know some things that you could share with the commission. I think the community forums could be an opportunity as well, especially when we think about reaching out to different communities across the state and involving them in the forums. I think there's a lot of opportunity there. And also including presentations from subject matter experts. I think there's something that could be done there. And then finally, looking into the kind of advisement pillar, I think the AB 1126 provides that the commission should advise a lot of different bodies in the state on how to address hate activity. It does not mention the Civil Rights Council specifically, but I think it's pretty clear that that's definitely a body that they could advise. So you should feel free to reach out to the commission for questions, and we will, answer them to the best of our ability or get answers for you. Moving forward, and just to give you kind of more context, the commissioners were I think the last commissioner was just appointed the end of November, and then a couple of weeks later, they stepped up to the plate and participated in the meeting. But this is the group of commissioners. They just elected their chair, Russell Roybal, he's in San Diego, and Bambi Salcedo in LA, I believe, as the vice chair. Neither one of them were able to be here today, but they are looking forward to addressing the council in January. So in terms of staying in touch with the commission and kind of opening lines of communication and sharing information, I think one thing to flag is that the commission, like the council, is a public body. So all meetings are open to the public, all documents are open to the public. It's subject to the same regulations as the council in terms of the Bagley-Keene Open Meeting Act, the Public Records Act. There is a website and a listserv. We encourage everyone to sign up for the listserv through the website, and we will send out notices and agendas about meetings and public forums and other resources that the commission publishes. There is also an email address of the commission that you can use to reach out to us, or you can also just email me as the senior advisor to the commission. And with that, I think we're done and happy to take any questions.
Do you have any questions? Councilmember Scher, go ahead. You're on mute.
Sorry, this is really exciting work, Alec, and it's great. I'm really looking forward to collaborating with you. The one comment I had, and I realize it's just getting off the ground and everything's brand new, and you got a bunch of new commissioners that are learning the ropes of how this works, as we always are. If you could go back to the slide about opportunities for collaboration for a minute, I think there's a couple you missed. So, for example, we also make recommendations to the legislature and to other people about ways, proposed changes to legislation or other things to deal with hate crimes. And we also host forums. So I think that there are several opportunities. All of the activities here are ones where we could really collaborate very effectively. You probably heard a lot about that from both Becky and Lily as well. So just really looking forward to all those collaboration opportunities. So thank you.
Yeah, fair point. Thank you for flagging that.
Thank you, Councilmember. Total agreement with what you just said. Thank you. Any other statements or comments by any of the other council members? Okay, do we have any public comment on this one?
Can you put the link to sign up for the listserv in the chat, please?
Sure.
There's no public comment. There was a general question about how to speak in the meeting, if you'd like to do that. And just as a reminder, you would just click raise hand in the Zoom during the public comment period. But other than that, no public comment.
You, Rachel. Okay. Well, thank you, Alec Watts. We look forward to working with you.
Sorry,
and-
Keith.
Oh.
I'm sorry, Chair Sandoval.
Yes.
I have a, before
I'm
we
sorry.
move on.
Councilmember Hahn, go ahead.
I was wondering whether or not maybe in Q1 of 2023, we could kind of discuss, we have so many subcommittees. There are a lot of opportunities, I think, for the council kind of reassess, you know, how much of our efforts are focused on regulatory efforts on some of our subcommittees, but then how we might allocate some of our resources and our attention on some of these other efforts, and what does it mean to collaborate, and how do we alleviate some of that efforts working together with staff. So all this to say is that I know that we have about, I don't know, I think we have like 13 subcommittees right now, and we keep on repeating them on the agenda. At one point, can we kind of from a larger body kind of assess, hey, let's sunset some of these at this point. Let's reassess where we can put some efforts and our goals. I mean, a little bit of a mini strategic planning for the council part, but understanding, you know, where are we going on a bigger picture in terms of our tenures, and where do we want to focus on for the next 2 or 3 years, knowing that we have, I think, a lot of momentum, like with California versus hate, obviously the hate work, and understanding like where we should be perhaps prioritizing some of our energy. I don't know if this was the space, but I think, you know, part of this is like, it's all you know, it's all like very big, things are starting, but then since we only meet every once in a while, I feel like if we don't start planning that, it you know, before we know it, the year's over again.
I'm open to having that discussion, council member. And I think it's always good to reassess and reevaluate at every meeting, but maybe we can have a focused attention on the very issue you raised, because there are a lot of work that's being done by our new colleagues and fairly new colleagues doing incredible work, and also speaks to the other powers or authority we have as council members, right? So I'm in total agreement with that as well. So we could maybe all put that in the back of our mind, that we're gonna have a more robust discussion in January during our next meeting, or February, whenever that is. Thank you.
Thank you.
I would also, I really support that idea, and would suggest that we, you know, agree now to put it on the agenda for next meeting. And I think to make it a useful agenda item, maybe consider whether or not staff could sort of work up some document that starts to make the connections, or starts thinking it through a little bit, so it's a little bit processed before we have a public conversation about it.
Councilmember Shore, thank you. Councilmember Iglesias. Councilmember Shore.
I think it's a great idea, and I think it would be great to be on the agenda. And I think it'd be helpful if some of the subcommittees also gave it some thought before the next meeting. Those of us who have rather broad purviews in particular about, but not exclusively, so that they could come back with specific potential recommendations as well. I do think we need to keep in mind that we also need to leave time for our routine responsibilities. We're always having to do new regulations for new state laws, et cetera, and there's some big ongoing projects, but it's always good to provide some focus and think about where we want to go. So I think it's a great idea.
Thank you, Councilmember.
And Chair Sandoval, there is another public comment that came in if no other council members have comments.
I
Okay.
just
Councilmember Brodsky.
Just real quick, one thought that just occurred to me is I think we want to make sure that there's no duplication of efforts. And in terms of efficiency and who can do what, I think that's a really big topic that we should include in the discussion of how we collaborate, just how we don't duplicate.
Agreed.
That's all.
Thank you, Councilmember. Rachel?
Yes,
said
there is a public comment. Brenda Lebsack has raised her hand. And Ms. Lebsack, you are unmuted now.
Oh, thank you. Yeah, I just have a question. I'm a public school teacher and a former school board member in California. I sent a question to Linda Darling-Hammond, the state board president, and on LinkedIn, and I haven't received a comment back yet. And maybe Alec Watts can answer this. We have a board policy administration regulation 5145.7 that's posted in all of our teacher lounges, maybe in the whole state of California. I don't know. I work in Santa Ana Unified School District, but it basically says that sexual harassment and non-discrimination concerning hate speech and things like that is the protected categories are based on actual or perceived skin color, gender, sexual orientation, pregnancy, race, etc. My question has been, using that word or, how can skin color and pregnancy be based on perception and not on actual, biology? I know that gender is based on perception and there's unlimited gender choices now in the state of California, and that the CDC says that kids can make up their own genders because gender identity and non-binary is defined by gender creative, and that is reflected in our kindergarten books in public schools now. However, I was wondering, how can skin color be based on only perception and pregnancy only on perception? Can you answer that question, please?
Alec, you want to speak on that issue, or?
Why don't I can get back to you on that. I'm not a subject matter expert on the laws and the nuances of that, but yeah, I'll look into that. Thanks for the question.
Can I ask one more question? My chat has been disabled. Is everybody's chat disabled?
As I understand at this time, yes.
Yes.
Okay. Thank you.
You can enter questions through the Q&A button, but
Oh,
the chat's disabled.
thank you.
Thank you. Anything else at this time, Rachel, in terms of public comment?
There's no further public comment.
Okay. Thank you, Alec Watts. I really appreciate your presentation. Again, we look forward to working with you. There are a lot of opportunities for collaboration, as Councilmember Scher identified, and so including the forums, including joint recommendations to the governor, the legislative office, and those kinds of other tasks and responsibilities. So we look forward to joining in that effort. Okay. Next, we're going to have agenda item dealing with consideration of proposed modified text proposed modifications to employment regulations regarding criminal history. I'll turn this over now to Councilmember Julie Walensky. And this is with attachment B for those who are looking to identify the document that's related to this particular item.
Thank you, Chair Sandoval. Good afternoon, everybody. I'll start with an overview of where we are in the rulemaking process, and then I'll give a summary of the new proposed modifications. So where we are is that the council previously issued proposed modifications to the regulation, along with an initial statement of reasons. And we received public comments during a 45-day comment period, including written comments from individuals and organizations. We had a public hearing at the last council meeting, which was on August 10th, and we received additional comments from members of the public and other council members. So the subcommittee has reviewed and considered all the comments, and we're proposing a modified version today, which incorporates some of the comments that we received. So if the council approves this version today, then it would move into a 15-day comment period. So that's just where we are procedurally. And now I'll shift gears to just a quick overview of the proposed modifications. And before I get into the substance, Chair Sandoval and I want to thank all the people and organizations who submitted comments, people who came in person, people who participated remotely, and people who submitted written comments. We very much appreciate your feedback and your suggestions. We are grateful for your expertise, your breadth of experience, and your perspectives. And we're also thankful to the other council members as well who offered their comments at the last meeting. We also want to thank the department, especially Senior Counsel Rachel Langston, for her work with the subcommittee. So now I'll just provide an overview of the proposed modifications. If you're looking at the black line in attachment B, it's certainly a complicated black line. With the earlier version, we issued a chart because we had also proposed just moving some stuff around. So some stuff looks like it's new text or omitted text, but it's actually just moved. And so I'm going to focus today only on the new proposed modifications, which are in double underline or double strike through. So that's what we'll cover today. So I'm just going to go through the regulation, the regulation briefly, and just kind of highlight some key areas. In general, the modifications that we're proposing today are in response to the comments we received, and the goal is to provide additional clarity. And there were some suggestions from commentators that the subcommittee did not propose incorporating here, and we will respond to all of the comments in the final statement of reasons. So today we're not going to go through each comment and say why we did or didn't incorporate it. We're just going to explain the new proposed modifications today, but everything will be addressed in the final statement of reasons. So I'm just going to go through with an overview kind of section by section. So to the introduction, we propose adding additional language just to give more context to both employers and applicants or employees, including that with limited exceptions, employers aren't obligated to check the criminal history of an applicant or a current employee, and that the Fair Chance Act is codified in the FEHA and subject to the FEHA's procedures. And in A4, we propose a clarifying change about state or local agencies. We propose adding A5, which is additional clarification on the limited exemptions in A4. We also propose adding A6 to provide guidance for when an applicant voluntarily raises criminal history prior to receiving a conditional offer. And again, I'm just going to go through quickly and provide an overview, but there will be an opportunity for comment both by the council and members of the public. So the next proposed modifications are in C, and C sets forth the requirements if an employer intends to deny the employment that's conditionally offered because of the applicant's conviction history. So in C1, we propose calling it an initial individualized assessment because it's before the preliminary decision. We propose additional clarifying language that this is a reasoned as an evidence-based determination. Then below, we propose adding language that having a benefit, privilege, or right required for performance of the job by a licensing, regulatory, or government agency or board is probative of the applicant's conviction history not being directly and adversely related to the specific duties of that job. There's actually a typo here, so I'd suggest we change regulator to regulatory in C1, capital A, little I. And then below in C1B, we propose adding additional language for what employees may consider when they're evaluating the mandatory factors in the statute. So one example is the statute requires considering the nature and gravity of the offense or conduct, and then the proposed modifications provide more detail as what this inquiry could include. And C1C provides additional information about evidence of rehabilitation or mitigating circumstances if it's provided at this stage. Moving down to C2D. And we propose some line edits for clarity, some changes to numbering and capitalization for consistency, and then a few additional items under evidence of rehabilitation or mitigating circumstances, and a sentence that any such evidence is optional and may only be voluntarily provided. We also propose C2D little 3, or I, as to what employers can't do. For example, require an applicant to provide a specific type of documentary evidence, such as a police report, or disclose their status as someone with a disability or someone who's experienced intimate partner violence. In C2E, that's the notice provision, we propose some edits to try and add a little more clarity on the deadline to respond, including when the notice is sent by email. We're proposing 2 days, which is just from the Code of Civil Procedure. In C3, we propose calling C3 is we propose calling it reassessment rather than final decision, and then clarifying that 4 is the final decision. And we propose some additional language on factors that the employer can consider about with respect to evidence of rehabilitation or mitigating circumstances. C4, we're proposing clarifying title, just final decision. And then we'll move to F4, which is job, F4, which is establishing job-related and consistent with business necessity. We just proposed one edit to this section, which was that if there's more than one conviction on a background report, the employer needs to say which conviction or convictions were found disqualifying. And we're almost to the end here, but in G, we propose omitting permitting from the title so that it's compliance with federal or state laws, regulations, or licensing requirements requiring consideration of criminal history. And then on H, with respect to the work opportunity tax credit, we're proposing adding a subsection 3, which makes clear that employers need to keep that information separate from the general personnel file and can't use or disseminate those forms or the information for any purpose other than applying for the work opportunity tax credit. And finally, in I, we propose some changes to additional clarity with respect to the definition of applicant and employer to add clarification. So thank you for bearing with me on that. Chair Sandoval, anything to add there?
Nothing to add. Thank you, Councilmember Walensky. Any comments from council members? Okay, we'll go with Councilmember Iglesias and with Councilmember Hong. Go ahead, Councilmember Iglesias.
Great, thanks very much. Thanks, a lot of good work here. I have a number of little comments, nothing substantial, nothing big. The first one is, I understood from prior experience that OAL in the first paragraph doesn't like the word introduction because it's not regulatory, not telling somebody to do something. So I don't know, I don't know, maybe staff could inform on whether that is still true or not. I know that sometimes we get different things from OAL, but I think that paragraph works without even taking out that word. I think the paragraph is very good and very helpful. And I'm just hoping that, it doesn't get flagged unnecessarily. Next in A4, I like the edit. I just want to make sure, I couldn't tell in my copy whether or not the end parentheses had been deleted or not. I know we don't want to delete the end parentheses, otherwise the edit doesn't make sense. And then in A5, I think the substance of the addition makes sense. I'm wondering if this could be placed earlier. It's a little awkward having the whole thing stated about what goes on and then say, oh, and by the way, this doesn't apply unless X. So I don't know, you might consider if there's a way of incorporating it before up into 4. Then in A6, the either or construction confused me because it seems like at least one reading of that would mean that the employer has a choice. They can either do one or the other, but I think you really mean both there. So you might want to look into that and revise it to make it clear that the employer can't use either of those. I think it's not, so I don't know how to say it, but the way I read it, it was a little confusing and seemed to give the employer a choice. And then in 6B, the language right now says after deciding to not, extend an offer or whatever. And I think what you probably mean is after making the decision that they have to, it's not just that after making, or after, yeah, you know what I'm saying? After making the conditional offer, not after deciding to make the conditional offer, because that would be an internal thing that may or may not be communicated. And then in C capital B, the next three subsections, it talks about the consideration of these factors may include. I'm not sure if you mean may or must. So just to raise that as a possibility. And then in C, let's see, I'm missing up here. The capital C below in that subsection, I guess it's subsection C, and then I'm sorry, I have this written down, but capital C, there's a couple places in the document where you use the word paragraph and subparagraph. And my understanding is that we're supposed to be referring to sections and subsections and stuff like that. So you might, that occurs there and also down below in D, II2. And then I just have two more small ones. And then, so in subsection, I guess, C capital D, let's see, there's a whole lot of very helpful information about how an employer needs to consider rehabilitation information, but there's really no guidance given on the employer considering challenges to the accuracy of the criminal history report. And I'm wondering if you might want to add something that gives some direction towards how an employer is supposed to manage if they get corrective information from an applicant. And then finally, in, I guess it's it's where it's Roman numeral 8 in your list of several things. There is a new factor that says the fact that the applicant is seeking employment. My assumption is that that's supposed to go to rehabilitation. And I'm wondering if it might be helpful and more clear to fill that out by saying the fact that the applicant is seeking employment in light of employment history prior to the conviction. Because it seems to me that's what would be the relevant, or could be the relevant way that the fact that the person is currently seeking employment would be relevant, would be if in the past they had not, or something like that. Does that make sense? Anyway, so those are my comments.
Can you flesh out the last point again?
Yeah, so you added as one of the factors that could be considered with regard to rehabilitation or mitigating circumstances in Roman numeral, 8, XII, the fact that the applicant is seeking employment. And for me, that alone is like, well, we know they're seeking employment because that's why they're an applicant. So I just thought it might be helpful to provide a little bit more context or detail as to why and how that factor could be relevant. And the thing that immediately came to me, but maybe this is not the whole thing or not what you were thinking, is if the person, because it seems to me it's going to rehabilitation, not to mitigating factor. So if it goes to rehabilitation, I think the fact that somebody's now seeking employment would be most relevant if there was a prior to their conviction, they weren't seeking employment. You know what I mean? That there's been a change. Does that make sense?
I understand your point.
Okay, that's all I have.
Thank you, Councilmember. I believe Councilmember Hong had her hand raised next.
Sorry, Chair Sandoval. I'm wondering if it makes sense. I had some questions to Councilmember Iglesias, to make sure I'm understanding
Let's do that.
where some of your comments are and the nature of them. Can I ask that? I also can just wait until the end and then.
Well, we could do that now. That's a good process. We could do that now.
What might be helpful is, yeah, I apologize. I wrote it down on a piece of paper and I didn't write down every subsection. How that confused myself. It might be helpful if you display on the regs or the proposed regs as a shared screen, and then it might be easier to identify them in terms of the location issue.
Okay. Okay. I mean, I guess I did have some clarifying questions about your questions, but maybe we should hear from the other council members and then we can go through the various questions together. That makes sense.
However you like is fine.
Okay.
Great. Councilmember Hong.
Mine are not quite as detailed and nuanced as Councilmember Iglesias's. Although I do agree, I was confused with the earlier section when it was either or, as if they only had one choice. I know that you moved it from the bottom to the top, and so I did get confused on that. So I want to second that area of confusion. My point was on little c1, when you for the initial individualized assessment, you had added a reasoned evidence-based determination, but what threw me was a lot of the information where the employer would get the evidence is after that assessment, and then the applicant could submit more evidence, because I wasn't sure where they would get that evidence at the initial assessment. So I guess I didn't really see how that would operate. So that was my first question. That was my first comment. Actually, that was it. That was most of the other items were, that was not as relevant. So I think that was it.
Okay. May I respond in real time?
Sure.
Sorry, I'm trying to think about how to make this most efficient. But I think that the reasoned evidence-based determination was in response to suggestions from commentators. I think the idea is that this is when an employer is intending to deny it, whether the conviction history has a direct and adverse relationship with the specific duties of the job. And so that needs to be an reasoned evidence-based determination. It can't just be stereotypes or some abstract reason that this is a bad thing that someone did. I mean, there needs to be a connection there. But then there's other opportunities with the notice and opportunity to respond for considering the evidence that an applicant might voluntarily provide. And so the reason evidence-based isn't to suggest that the applicant is supposed to provide evidence, but more that the initial determination that the conviction history has a direct and adverse relationship needs to be based on reason and evidence.
Okay.
And can I also ask about the either or, because I just want to make sure I'm understanding grammatically what the concern is. So is that in A6 saying the employer must not consider either A or B? And so the goal there is to say employer can't consider A and employer can't consider B. Is that the same? And Tim had also identified that. Is that the spot that you're looking at there?
Yeah, that's the spot I was looking at. And I definitely get the intent, and I agree with the intent. And I'm just tripping over the language because I don't know. If others don't have a concern, then maybe I'm just misreading it. But you understand what I'm talking about.
I understand what you're saying.
Yeah.
Councilmember, we'll take a look at the language construction.
Great. Thank you.
Thank you.
I'm not sure if Councilmember Shore or Roscoe is next, but either one could go next. Do you have anything else to add, Councilmember Walensky? Or
Oh, just
Councilmember
thank
Hong?
you to Councilmember Hong and thank you, Councilmember Iglesias.
Thank you. Okay, we can start off with Councilmember Shore and then Brodsky.
Thank you. A couple of things. I appreciate the comments, the prior comments, and I agree that either or can be a little confusing, although I agree with the intent of it. In light of Councilmember Iglesias's comment about deleting introduction. I don't know, just something to check whether you can have 2 paragraphs before you start the numbering, or if you have to give it a number, which is really a problem in an existing set of regs. So just a thought. My first comment is, at least on my printout on the 4th page, it's C1, initial individualized assessment. And it's just a grammatical suggestion, I think, and as opposed to a dash between an individualized assessment / a reasoned blah, blah, blah. I would start a new sentence saying an individual assessment is a reasonable evidence-based determination. I just think that will be clearer to people if you break that into a separate sentence. But I agree with the addition. In 1A, I'm afraid as I was reading this, I caught some things you didn't change this time, but I think they're worth pointing out. This refers to determining what constitutes a direct and adverse relationship, but under adverse relationship, I don't believe it refers to direct and. I think it just refers to adverse. And I think that is probably a broader and more accurate statement, although I'm not sure off the top of my head, but I do think if you compare that to F4, it says the policy or practice of considering criminal convictions creates an adverse impact, as opposed to this one that says a direct and adverse relationship. And I just want to be careful about the language we're using. They're not necessarily the same thing, but it's just worth looking at them in comparison to each other and making sure we understand what the implications of that are. In the next, in C1, a little I, little 1, I agree with the concept completely. I had one question whether probative or determinative is the right word there. I think it could be that if they've been vetted by a licensing board, then that's determinative that it's not appropriate as opposed to probative, but that's a question for consideration. I think the sentence could be a little clearer. I got lost in it. Probative of the applicant's conviction history not being directly, it might be something like more probative of the fact that the applicant's conviction history is directly and adversely related, or is not directly and adverse related. It's just a grammatical change. I got lost in the sentence. So I would probably say is probative or determinative of the fact that the applicant's conviction history is not directly and adversely related to the specific duties of that job. That's just a grammatical change, but you can tweak it how you'd like, but I found the sentence confusing as drafted. Not that I agree with the concept completely. And let me know if you have a question as we go along, and I'll try and respond if that's appropriate for you to ask a question. In little C1B, I think there's a couple of things there. One is I think it may be helpful to make the fact that the employer is not required to use the assessment form a separate number or separate subsection. I think that, and that it would follow, or whichever way, but I do think then you've got it right, that whether or not they do, it must include a minimum consideration of following factors. I started a little bit with adding whether disability, including but not limited to past drug addiction or mental, it should be disability, not impairment. Contribute to the offense about whether you want to say anything there about, that cannot be mitigated pursuant to the other section. I think it's really important to keep any disability related things tied to the possible mitigations of reasonable accommodations or treatment. And then I just had some questions about little g, whether youth, childhood trauma, sexual or domestic violence, human trafficking, duress, or other similar factors contributed. Because later on, that list also includes dating violence. It's in 2 places in the regs, and the other place includes dating violence, and this one doesn't. And I believe in the prior version, it included stalking, which neither of these include, but seem to me to be appropriate. So my question just is about parallel terminology and then how inclusive we are using dating, violence, and stalking as enumerated examples. And then the next place I go is to, let's see if I can figure this out. It's C1D little I capital Roman numeral 5, whether the conduct arose from the applicant's disability or disabilities, and if so, whether the likelihood of harm, etc. I think significantly mitigated or eliminated by reasonable accommodation for the applicant's disability or disability, or has been mitigated or eliminated by treatment or otherwise. So it may be that medical treatment, not an accommodation, has resolved the problem, or it may be that a long-term disability, someone gets surgery and they no longer have a disability. So I think I would add that phrasing there at the end, or has been mitigated or eliminated by medical treatment or otherwise, to the provision of a reasonable accommodation phrase. I have to say on Roman numeral 7 there, I wasn't quite sure why. I guess if the assumption on bonding under a federal bonding program is that if you're able to get a bond, you're good risk. Is that why that's in there? I just wasn't clear. I don't have an objection to it. But it might be worth explaining somewhere in the FSAR. And then documentary evidence may be included, but it's not limited to. This is little Roman numeral 2, 1, capital 4. Documentation confirming the existence of a disability or disabilities. And any reasonable accommodations or medical treatment or any other documentation demonstrating rehabilitation. So I would add documentation of reasonable accommodations or medical treatment. And then on the same page, at least on my printout, in little 3, parens 3, that's where the dating violence appears. It doesn't appear in the prior sentence. And then in okay, F4A is where it says adverse impact as opposed to direct an adverse result, impact. And then the next place I had a concern was, it was really just sort of a question, was on where we're talking about the work opportunity tax credit in H. And I liked, oh wait, I missed something. Let me go back. Let me go back to where we were on documentary evidence, which is little 3, an employer is prohibited from various things. 3, requiring a specific type of documentation, documentary evidence. And I think we need to include in that list medical records or diagnoses, because those are never allowed to be added. And I think there may be one other place where you have a list of prohibited required documentation. It should always include medical records and medical diagnoses if related to disability. And then, sorry, now I'm back to the work opportunity tax credit. And my only comment here is just, you may have made the decision not to include it, but there was public comment that suggested it would be helpful to notify the applicant why this information is being gathered in this instance when they can't otherwise ask for criminal history information. And you may have made a conscious decision not to include that, which I wouldn't second guess, but it was, I thought, a comment worth considering that I didn't see reflected here. And that's it for me. Thanks.
Thank you, Councilmember Schur. Councilmember Brodsky.
I just had a couple. I mean, you've been deluged with these things, and I just had a couple of thoughts. One is, I think we talked last time, but I'm not 100% sure about moving the definitions to the front. And I wondered if you had given any more thought to that, because I think the definitions are really important for a way to start out when you're reading them, because then rather than waiting to the end. So I would suggest maybe the next time around thinking about putting them up front. And I'm not sure, as Dara pointed, I'm not sure how you would, if the 2 introductory paragraphs have their own number or have to have their own letter. Maybe, I don't know, but maybe after the introductory paragraphs, then the definitions could flow. The only other thing I just wanted to bring up, which is just kind of occurred to me as I'm listening to the other comments, is that an individualized assessment, this is now in little c. I'm most familiar with that term as it's used in the disability context for how an employer has to make a determination as to whether someone has a disability that requires an accommodation. And it's a individualized assessment is kind of a term of art. And so I wondered if it's confusing to use that here. If not, and you opt to go for it, because it does appear here and then other places, I would suggest, I didn't like the hyphen either. For one thing, it kind of narrows the definition of individualized assessment in a way that I'm not sure that you might not want to have it narrowed that way. But if you do want to define it that way, then I would take out the part and just say the employer must first conduct an individualized assessment of whether the applicant's conviction history has a direct and adverse relationship. I don't think you need the reasoned evidence-based determination, because when you get down to C1B, where you go what must be in this individualized assessment and list them all the factors that are part of that history, you're already doing that. It's like show, not tell. You don't need to show what it is, or you don't need to, tell what it is. You're actually showing what constitutes that individualized assessment. But I do, whether the individualized assessment term is used or some other substitute way to describe this thing, I just, as you go back and think about it, whether it is confusing to use the same term that's used in the disability context. Anyway, that's, I think that covers my thoughts. Thank you. Thanks.
Councilmember.
This is a lot of work, but it's so complicated. I really, I'm really, it's got so many moving parts, so thank you.
Thank you for your comments. Councilmember Hong, Councilmember Shore, are those new hands being raised? Okay.
Mine is, but mine's just administrative. I feel like we struggle with this every time. And so my request is in the future, could we ask staff to actually number the pages for the attachments? So that way we all know what page we're talking about. I struggle with the big A, little a, I can never find it. And so I feel like as we move forward with, we're gonna have more of these packages. It just helps if we know page 3 on attachment A, then we'll all be at the same page. Because that way we can always save our notes and we're not having the same conversation. I do feel like I live my own deja vu in some of these meetings because I try taking notes, but you guys are so intensely, wonderfully detailed. It puts me to shame.
I would agree with that recommendation. Hopefully, moving forward, we can have that. Thank you so much for that recommendation. Anything else, Councilmember Hong? Okay, Councilmember Shore?
Just briefly, I even though I had a number of comments, I think this was a great rewrite. This is a really complicated area, as I know from struggling with criminal history and the housing regs, and makes me want to go back, and you've done a good job on some of these, so I want to go back and look at what we did and see if we need to make some changes. So thank you for that.
Thank you, Councilmember. Again, thanks again to Councilmember Walensky and Rachel Langston for the assistance in Adam Romero. Do we have any other council member comments?
Just from me in response to the comments. So I thought we could maybe go through and address each one in the meeting, but there are a lot of them and I will miss some, I know, because I'm taking notes. So I think it probably doesn't make sense to respond to each council member's comment in real time in the meeting, but we will certainly consider all of them. And I appreciate all the feedback. I will respond just to one, your question, council member Share, about direct and adverse, and that's just language from the Fair Chance Act. And so that's the standard in the statute that's been incorporated into the fee hub.
So then it probably needs to be consistent in both places, maybe. Take a look at it.
Yeah, I think one of them is talking about adverse impact, but because we talk about the Fair Chance Act, which uses that direct and adverse language. And then also just other elements. But anyway, I think that's why it's different, but I could be mistaken.
We'll take a look at it, Councilmember Shore. Any other comments from council members? Okay, Rachel, do we have any public comments on this item?
We do. I'll first unmute Molly Lau, who has a comment. Molly, you should be unmuted.
We want to extend our appreciation to the council's efforts on these regulations and for considering our previous comments and drafting this iteration. We commend the council for the additional language that clarifies that employers and their agents must be exempted by law in order to conduct background checks in A5. We also commend the council for adding language that will help with the candor trap that applicants often face in A6. We also commend the council for the additional language that clarifies and expands the definition of employer to include any direct and joint employer, any entity that evaluates the applicant's conviction history on behalf of the employer or acts as an agent of an employer, directly or indirectly, any staffing agency, and any entity that selects, obtains, or is provided workers from a pool or availability list. We commend the council for elaborating on the factors in C1B1 to 3 by adding considerations to the nature and gravity of the offense or conduct, the time that has passed since the offense or conduct and or completion of the sentence, the nature of the job held or sought. We ask for these clarifications in the various sections here relevant to this modification. In subsection C1B1A, we ask that you further clarify that employers are expected to know that a wide range of conduct may result in a conviction under particular criminal laws, and convictions may be based on indirect liability for other people's actions, e.g., aiding and abetting liability. We also request in subsection 1, in the subsection, that you include a consideration of whether the applicant pleaded nolo contendere, no contest, pleaded guilty, or was convicted after trial, and that employers should know that 94 to 97% of defendants enter into federal or state plea bargains not as an admission of guilt, but because of the coercive power of large sentences. In subsection C1B2, we ask that you elaborate that employers cannot consider any such conviction when 7 or more years have passed since release from incarceration. Since employers are often unfamiliar with what records they can consider, if any at all, and to provide clarity about how these laws interact with ICRA. We also urge the council to consider adopting language making clear that all relief available under the rest of the VHA is available under the Fair Chance Act. Finally, we recommend that the council consider adding language that will help protect applicants with any arrest or conviction record whose background checks typically take longer than those for individuals without records. We encourage this change because employers may be confused about their obligations to follow the individualized assessment process if they are revoking a job offer without having seen the results of the background check. Once again, we appreciate the council's important work on these regulations, which will impact countless individuals who have prior convictions. We look forward to continuing to engage with the council as it continues its rulemaking process. Thank you.
Thank you, Ms. Lee.
Thank you.
Any other public comments, Rachel?
There are several that came through in Q&A that relate to this agenda item. There's one from Joshua Kim, who thanks the council for its work and notes that some employers revoke a conditional job offer when a criminal history background check is delayed. Neither the existing nor proposed regulation makes it clear that the revocation violates the Fair Chance Act. It would be helpful to add a new subsection to clarify that revocation of a conditional job offer on the basis of a delay in obtaining or failure to obtain criminal history information of the applicant is prohibited. So thank you for that comment, Mr. Kim. Let's see. There's a comment that agrees with Councilmember Scher regarding words. This is from Brenda Lebzak, noting that the words really matter, or either, direct, etc. I've seen words in some of our laws change out a word from shall to may, which totally changed the meaning. And then Bruce Wolf made several comments on this item with regards to disclosing disability or health records following the ADA on disclosure is probably best. He also notes definitions at the front as standard constitutional construction. And then he asks, is the goal to these amendments to increase disclosure and exposure to employers? So I don't know if there's an answer to that, or it will be answered later through the process.
Anything else, Rachel?
There are several other comments from Ms. Lebzak that are not related to this agenda item, and I will just note that the Q&A box is available to the council members for their review. And so if there is any response other than Alec Watt's earlier response to Ms. Lebzak on any of these comments, they can be made at the end of the meeting when we go on to a general comment period. And I do apologize. There was one more comment from Mr. Wolf noting that there is classification of temporary versus permanent disability. And then we also have another commenter on the Zoom, Ashley Dennis. Ms. Dennis, you are now unmuted. Oh, I think you may have self-muted.
I'm so sorry. My hand was raised unintentionally. I'm so sorry.
Oh, not a problem.
My bad.
It's easy to do. Other than that, I don't believe, I don't believe there are any further comments related to this particular agenda item.
Great.
I
Thank you, Rachel. Go ahead, Councilmember.
I just want to reiterate the thanks and appreciation for everybody who is providing comments. Thank you so much to members of the public who are commenting, and thank you to the other council members. This is a complicated endeavor, and really appreciate everyone's feedback in the process.
Thank you. I'd like to echo that sentiment. All right. So we have action here, and this is to move the modified text forward for another 15-day comment period. Is that correct, Rachel?
That's correct.
Okay. Do we have a motion on that item?
So moved.
Do we have a second?
Second.
Okay, can we take a roll call, please?
Chair Sandoval.
Aye.
Councilmember Brodsky,
Aye.
Councilmember Hong,
Aye.
Councilmember Iglesias,
Aye.
Councilmember Alude,
Aye.
Councilmember Schur,
Aye.
Councilmember Walensky.
Aye.
Okay, thank you, everyone. Our next agenda item is consideration of modified text, proposed modifications to employment regulations relating to religious creed discrimination and accommodations. I'll turn this over to council members Dale Brodsky and Julie Walensky.
I'm going to take the lead on this for now, but Councilmember Walensky will jump in as if need be, which probably will be. But we took your the sentiments expressed at the last meeting quite seriously and went back to the table and did lots more research, considering how to amend and bring up to date the religious creed regs. And in doing so, I mean, we had used in the last time, you may remember that we had explicitly said that health and safety, endangerment to one's health and safety or employees' health and safety could constitute an undue hardship. What we did was we used that specific example, but to look at the picture more generally and look at it in terms of the existing language of the regulation. And so I just want to kind of walk through with it. And as a preliminary matter, I want to say that undue hardship in FEHA is different from Title VII and ADA. Title VII does not include disability discrimination. That's not listed there. Religion is. Disability discrimination is covered under the ADA, and they have slightly different standards. FEHA is very different because it's all both religious accommodation, reasonable accommodation for religion, and reasonable accommodation for disability are both covered by the same definition, which is in 12926U. And it is a different standard than the federal standard because it requires employer has to show that there is a significant an action that requires significant difficulty or expense in order to prove an undue hardship. That standard applies whether it's disability or religion. That's the definition that we are using here. And the reason we know that is because 12940L, which is the statute that we're implementing here, cross-references back to 12926U. So that's the overall framework that we're working with. And what we did then was we reordered some things, and I think you'll now see the draft is a little more logical because it talks about reasonable accommodation first, then we go into the undue hardship and what the employer can do if the employer wants to deny an accommodation. So if you look at the enumerated, so what we did was we just really reorganized what had been previously B, little b, and it is now little d. And each of the factors that may go into establishing whether there's undue hardship on the operations of an employer or other covered entity. These are some of the factors. What we did was we added, the only one we added from the old list was number 8. And that was to clarify that an operation of the facility may include, and this is just as by example, the impact on other employees or customers. And this is supported by case law, Ninth Circuit case law. We added 2 cases, Balint and Tooley Martin, to the authority cited, both of which say that the employer may show undue hardship. The undue hardship may be to the operations of the employer's operations may be disrupted because of their impact or the accommodation request's impact on other employees. Whether that it means, for safety reasons, for health reasons, for whatever reasons, that is part of it. The other thing we did in revising this is that we tracked the statute more closely in talking about segregation and when what happens if an accommodation requires segregation. So if you'll see, what we did was we omitted the language at the end of the old B, which we thought in analyzing it really overstated the statute, went beyond. And we instead included a new section E, an accommodation of an individual's religious dress practice or religious grooming practice is not reasonable if the accommodation requires segregation of the individual from other employees or the public. And we tracked the language in the statute closely so that we could mirror that and be more accurate. So those were really, we really appreciated the input we got last time. It was very helpful in guiding how we analyzed this. And we're hoping that this draft, and it is it is just a proposal. It would go to for public comment if you guys approve. But we think it comes, we think we tackled the issues and without endangering anything else.
Thank you, Councilmember Brodsky. Councilmember Walensky, do you want to add anything?
Nope.
Okay, let's open it up to other comments from council members. Okay, so Councilmember Hong and then Councilmember Iglesias, go ahead.
Thank you for your work on this. I thought it was very gracefully done. And so my only small comment was on D8.
D8.
Yes, when you say the impact of the accommodation on the operations of the facility, just in terms of parallel language, before it was used with the establishment, right? And so I was wondering if there was a reason why it was just the facility and not adding the establishment as stated in the other areas above.
No, I don't remember that there being any reason to treat it differently, except that the cases that we cite have to do with facility, but an establishment seems to be, it would be equally appropriate to include that if you think we should.
Well, just because that's for number 1 and number 3, they include that. I wasn't sure if it was a term of art. I don't know what the difference is between an establishment or a facility. And so, but I just thought for the sake of consistency, you would want to mirror it. But if the case law is very specific to the facility, then one would argue that I would want to be an establishment, right? So I don't know how you want to address that. I just saw that.
Yeah, no. And for example, in 4, we talk about, I mean, that one is operation. It doesn't say the word establishment. That was from the old language. We didn't change the old existing language.
Okay, that was my only comment.
Thank you.
Thank you, Councilmember Hong. Next, Councilmember Iglesias, and followed by Councilmember Shore.
Great, thank you. So I feel like I'm a little confused, and I need to be enlightened here. So, and because I'm not really attuned to this area of law. So in my understanding, tell me if this understanding is correct or incorrect. So my understanding is that an employer must provide an accommodation if it's a reasonable accommodation, but doesn't have to if it's an unreasonable accommodation, and that an accommodation is unreasonable if it creates undue hardship on the employer. Is that correct?
Not exactly from how I analyze it.
Okay, why don't you enlighten me, please?
There can be a reasonable accommodation. The person can have a, propose what would be a reasonable accommodation. The employer says, I'm sorry, we can't do that for X, Y, or Z reason. It creates an undue hardship. Let's say they need to have it's a small office and they need to have all new ventilation put in for something, and it would cost $100,000. So the employer might be able to say, no, we can't do that. So that's in kind of recognizing that, that's why we changed the language in A to say that it's basically to say that you could have a reasonable accommodation, but that it would create undue hardship.
Okay, all right.
Necessarily, it's not necessary. You could have if it's not a reasonable accommodation, somebody could propose something that is not reasonable. And
Right.
then it wouldn't require the employer to come up with a defense of undue hardship.
Right, right.
So it's a reasonable accommodation, and then the employer has the burden of proving that it would create an undue hardship. Because it would have a significant impact on its operations or establishment or whatever.
Okay, all right. Yeah, I think.
Do you agree with that?
Who are you asking?
Oh, I was asking Councilmember Walensky. Do you agree with that?
Yep, that makes sense to me. Which is why they're in separate provisions. I mean, there's a discussion of what is a reasonable accommodation, and then there's the separate discussion of what is the undue hardship.
Okay, it might be helpful to add something that says employer does not have to provide an unreasonable accommodation, and an employer also does not have to provide a reasonable accommodation that creates an undue burden or undue hardship. Because I don't know if it would be helpful to other people, but I'm trying to wrap my head around. So anyway, thank you.
Frankly, I think that would be more confusing.
Really?
But, yeah.
All right. Let's see. And then in D, I think in terms of, I understand these factors, but I think it would be helpful for a reader for clarity to sort of group the factors that have to do with the relevant establishment or facility, and then also group the factors that have to do with the employer or covered entity, because right now they're split. So there's parts on the establishment or facility in 1 and 3, and then there's ones about the employer or covered entity in 2 and 4. And then also, now in 8, there's something on the facility. So I just found it a little bit kind of confusing to go back and forth between establishment, facility, employer and covered entity, back to establishment and facility, back to employer covered entity. So you might consider grouping those. And then the last thing is, let's see, hold on. Oh yeah, so the factor number 6, so D6, I'm not sure of the source of this, and maybe I'm confused, but it says as a possible, it seems to me what it's saying, it's possible that this could be the reason why something would impose an undue hardship. And it says the reasonable notice to the employer or other covered entity of the need for the accommodation. And just kind of trying to think that through, it seems to me that, you know, if a person doesn't provide reasonable notice, that seems like that should go to the time that the employer has to consider whether the accommodation is legally required. But the fact that there's been a short notice, let's say, I'm not sure how that or why that should go to the idea that that particular accommodation causes an undue hardship. Do you see what I'm saying?
Well, I agree with you, and 6 and 7 both don't seem to jive. I'm not sure I agree with on the grouping, because I think that, I mean, I think there's some logic in the way that they're listed, but those two were there. They are just they were existing in the religious accommodate in that reg, and we just moved them. And we can certainly talk about, you know, they certainly don't fit, and the others, all the others, the other 6 or can be related back to U, 12926U. For example, 1 is U1 and 2, 2 is 3, U3, R3 is U4, R4 is U4 also. Number 5 is correlates with U1, and 8 correlates with U2. Those two, what are 6 and 7, do not flow directly from the statute, but they were there in the existing reg. So we can take a look at why they were there and if they have any purpose or function.
Okay, thank you.
And just to add to what Councilmember Brodsky said, we can look at the prior regulatory history also in terms of what was proposed and why the prior council did what it did, because as Councilmember Brodsky said, 1 through 7 were just moved from what used to be B to now D. So we can take another look at that history.
Great, thank you.
Anything else, Councilmember Iglesias? Okay, Councilmember Schur, you're next.
Thank you. I agree with what was just said, that it would be helpful to take another look at a couple of those. Let me start with what I think is the easier one. E, the restatement in E, you eliminated the unless that accommodation is requested by the employee, and I think that is an important provision to include, and I would restore it, please. And also, the way this is now framed leaves it a little bit unclear that if they turn that down, that they still have to consider other reasonable alternative means of accommodation. And I think we should make that clear. And we could do that either in that provision or just adding a separate provision somewhere that says, you know, before you deny it, you have to consider any available reasonable alternative means of accommodation before you deny on any of these grounds, which sort of is a concept that comes out of the ADA, but seems to me would be equally applicable here. It may be helpful to add an undue hardship definition. Easier said than done, I know, but may be helpful to try and provide some guidance there, if there is some from the case law. Next, I agree what was said about time. Which is that reasonable notice. I think that's a concept that has to be taken in concept. You could have very short notice that's perfectly reasonable depending on what the accommodation is. So I think that one is, if you look at it again, it's worth looking at.
I 100% agree.
Yeah, the biggest one I don't really know quite what to do about is 8, because it's a loophole that wipes out everything else. Any change can arguably be an impact on the operation of employees and other people. and I don't know how to narrow this if it's in the statute, but that is an enormous, enormous loophole. There are no, that's just about every accommodation has some impact on somebody, or else there wouldn't be any debate about it.
Don't forget what the definition of undue hardship is, though, in the statute. It has to be a significant difficulty or expense.
Well,
It's not just anything.
I understand that, but as that reads, it is so broad that I really worry about it. And I think it would be good to tie it back in some way, you know, an impact on the accommodation that rises to the level of an undue hardship. I don't know. I mean, I know that's sort of presumed, but that is, and I don't know if there's any other way under the case law to narrow that, but that is, I don't know if I'm giving you an impossible task, but that is an incredibly broad loophole. And I can't speak, I don't work in this arena, so I don't know if it's one that it creates a huge barrier for people, or if folks who are more familiar with this arena want to address it, but that is my concern. So, and that's the last of my comments. Thank you. Tough area. Thank you.
Thank you, Councilmember Sure. Councilmember Iglesias, do you have your hand up again, raised again?
Sorry, no.
No worries, thank you. I agree with Councilmember Sure. If you could take a look at item 8 and see if there's some way you could address the issues that were raised by Councilmember Sure. All right, any other comments from the council members? Okay, any public comment?
Yes, we do. We have a public comment from Alan Reinach, and I hope I'm pronouncing that correctly. And Mr. Reinach, you're unmuted, or you're muted, but there you go.
Thank you very much, Rachel. And yes, you did pronounce my name correctly. I've been the executive director of the Church State Council now for almost 30 years. I've worked with this council going back about a decade on the religion regs, and also worked closely with the with CELA, California Employment Lawyers Association. I missed the last discussion, but Noah Lebowitz filled me in and on his concerns and how we got to where we are here. I was planning to speak just to the sub 8 D8, but in light of council members' comments, I'd like to add a few observations. First, to Council Member Iglesias's attempt to kind of frame this area. Reasonable does not apply to the person requesting the accommodation, whether what they're asking for is reasonable. We deal with it here in the regs in B, that a reasonable accommodation is one that eliminates the conflict between the religious practice and job requirement. Because the problem is that management says, oh, you don't work on Sabbath, fine, we'll give you 2 Saturdays off. That's reasonable. It doesn't work for somebody who won't work on Sabbath, which has been my bread and butter for so many years. So reasonable really goes to, if the employer can eliminate the conflict, great. And if they can't, the defense is undue hardship. Apologize for that. We'll silence that. And so when it comes to undue hardship, comment first on number 6. So the Supreme Court in the EEOC Abercrombie case in 2014 noted that the notice requirement that is so typical in prima facie case requirements in court is not in the statute. And notice, I mean, either obviously the employer is not going to accommodate if they don't know that the person needs accommodation. I don't see that 6 is helpful here in terms of what is an undue hardship. I mean, I suppose theoretically, if an employer had such short notice, that something really became dire, that could be a factor, but I don't, to the extent that the regs are here to really educate and guide employers particularly, I don't see that as being particularly helpful. And I guess I'm not sure how 7 helps. But let me speak to 8, because the problem that we have in accommodation cases is that employers are so oriented around treating everybody the same, about neutrality, about equality, that they don't understand that when it comes to accommodation, those needing accommodation, they have to give them different treatment, special treatment. In Abercrombie, the Supreme Court said favored treatment. And that, inevitably, yes, as Councilmember Schur pointed out, there will be impacts on third parties. Now, customers is clearly atextual. There's nothing in the statute that would really warrant adding customers. But as far as impacts on coworkers, the Supreme Court clearly carved out seniority rights in terms of scheduling, that trumps. And that's been very clear that if someone has a collectively bargained right to a shift or schedule, then that's going to trump the need for accommodation. The cases cited, there's lots of language, including in the cases that Councilmember Brodsky added here. Balint was a case that I was involved in, and then Tooley goes back before my time. But in both cases, the plaintiff won. And I'm not aware of any Ninth Circuit cases that have really turned on impacts on third parties constituting an undue hardship. And I think that goes to Councilmember Brodsky's point that, yeah, we have a good standard. We have the significant difficulty or expense standard. The problem is we don't need to encourage employers to be focused on neutrality, because if they see this and it says, operation on the facility, including the impact on other employees, well, other employees are going to grumble a little bit, or they have to pick up an extra shift or some other impact, they're going to cry undue hardship. I think on balance, the problem is not the impact on other workers. If there really was a significant impact on workers, the employer clearly would deny the accommodation. The statute, of course, doesn't talk about impact on workers. It talks about the impact on the operation of the company itself. And so in order for the impact on coworkers really to, under the statute, become an undue hardship, it would have to impact the operations in a significant way. So I think that 8 is actually counterproductive and would make our kind of nuts and bolts cases much more difficult than they already are.
Thank you, Mr. Reinach. If this moves forward for the initiation of a formal rulemaking process, you have an opportunity to provide further comment in writing. But thank you for your participation today.
And let me just respond, if I may, just real quick, just by reading just a piece of a quote from Balint. Undue hardship may also be present when an accommodation would cause more than a de minimis impact on coworkers, such as depriving coworkers of seniority rights or causing coworkers to shoulder the plaintiff's share of potentially hazardous work. And then there are other cases, and the one that was cited originally, Opuku, is also relevant on this point in terms of what could be entailed by operations, and how Councilmember Wolanski and I looked at it is we thought it would be helpful to give an example of that, because one of the purposes of regulations is to educate people, or employers and employees on the whatever topics that we're regulating on. And So that's why we thought it would be important to include that. It's already in the case law. So, you know, we want to have people be able to use these regulations to the best of our ability.
Thank you, Councilmember. Councilmember Sure, you had additional comments?
Yes, sorry, I forgot one. I seem to be a little disorganized today. I apologize. In the last draft of this we looked at, you had included some other examples of reasonable accommodations, particularly, and some of these really go to the segregation issue. And I thought they were really good examples, such as telework or a private workspace, alternative work arrangements. And I think it would be helpful to go put those back in if you could. I think, and there may be other examples suggested by the public, but I think more examples of things that might be reasonable, right, that may include, are helpful. And I particularly thought those two were helpful. So I was sorry to see them disappear. I realize you kind of restructured it, but there is still a space in B to add some additional examples. And I just wanted to put that out there. It's not mandatory, but we find examples. I find examples and regulations to be extraordinarily helpful. So
Did you
Thank you.
say you thought they would be helpful in D as in dog?
no, B as in boy,
As in boy, okay.
which is where there are already examples.
Thank you, Councilmember. Councilmember Iglesias?
Yeah, thanks. Just one last comment. I do think it would be helpful to add in, if you could, a definition from the case law of undue hardship, just so that for clarity and for the reader to know what it, you know, what the standard is, if it's fairly resolved and there's some case law behind it, because otherwise the phrase undue hardship, obviously it's not self-defining, but it would be, I just think it would be helpful to include.
I have not seen a hard and fast definition of undue hardship. Part of the reason is because it is so fact intensive, and it will vary from person to person, whether whether an accommodation that's requested would constitute that. The statute that you use, I mean, the definition, the factors that we've talked about, the definition, that's about as specific as I've found. We can continue to look, but I haven't seen anything in all the cases I've read where there's a concrete universally accepted definition.
Thank you.
Any other comments by council members, from council members? Okay, any public comments?
Yes, so I believe in response to Councilmember Brodsky's response to his comments, Mr. Reinott responded, right, but in Opuku, another one of my organization's cases, the plaintiff won and the impacts on coworkers were not sufficient to constitute an undue hardship.
Yeah, that's one of the cases that we cite as part of our, that was the original case in the original authority section, Opuku. And then we added these two others.
And then there are a number of written comments from Ms. Lebsack. Ms. Lebsack, I saw you had your hand up earlier. It might be more efficient if you'd like to address the council. Would you okay, good. I see your hand up, so I will unmute you. You're self-muted, but there you go.
Okay, thank you so much. And thank you for an opportunity to give input. I am the founder of the Interfaith Statewide Coalition, and I do work with a lot of diverse religious groups, imams, priests, and rabbis and pastors of various races and language groups. And I do think Mr. Iglesias has a very good point that undue hardship needs to be specifically defined, because people of faith are feeling that our environment is becoming much more hostile. In many different congregants are expressing it in many different types of, whether it be Jews or Muslims or whatever. based on this gender identity, if we're not affirming all these many genders that are now being affirmed. And I know as a teacher as well, Gleason, in our schools, they have given out 50 different pronouns. And we want to know, if we do not use these pronouns because it doesn't go with our faith, are we going to be accused of hate? Are we being accused? I mean, this is very hostile. Can anyone answer that question?
I'll respond to that. So as a general matter, we don't provide legal advice or counsel to individuals who are providing comments, but I do encourage you to look at all laws, including federal, state, and local, because there are some issues related to the items you addressed that are directly addressed by guidance on those items, but we don't generally provide legal advice or counsel to public comments.
No, okay, I totally understand that, Mr. Sandoval, and that makes sense. So I guess as you are determining regulations and definitions, undue hardship is very important, because when you're talking about just offending somebody because maybe your beliefs don't align with their beliefs, that gets into some very, are people of faith going to be accused of, could they lose their jobs if they don't affirm all these many genders and all these many sexualities? And I think that's something that we would like an answer about. And I know you're not a legal person, but maybe when you're giving definitions, because when gender identity, when your organization came up with the definition for gender identity, are you under any obligation to do a press release when you change definitions? Because literally in July 2017, that definition changed the construct of humanity, because it wasn't just male and female. Now it was both genders, neither gender, or anything in between, including fluidity. So that's a huge change that took place in 2017, and nobody knew it. Adults were never told, and the only way I discovered it is with children's books, preschool books coming from the Human Rights Campaign and the Teachers Union. So I think that just general citizens, adult citizens in California need to know when these huge definitions get changed. Do you know what I'm saying? Does that make sense?
I understand your point of view in terms of what you're expressing. However, let me just say to you that, as I mentioned to you, we don't provide legal advice or guidance in response to public comments. But with regard to protections afforded to individuals based on gender identity, again, you can look at the Department of Education. They put out guidance. The Civil Rights Department has put out guidance, and the federal government has put on guidance on that issue. So I just redirect you to that.
Yes, and as I put in my comments, that unfortunately, when those things first started coming out in the health framework of expansive and evolving genders, when Asian, non-English speaking immigrants and Hispanic and Arabic immigrants wanted to give their input, they were denied access because the California Department of Ed wouldn't give the document in any other language but English. And so, we tried to fight that through OCR, but we're denied. And so to me, it seems very hypocritical that we are saying we respect diversity and we're fighting for equity, and yet we discriminate and exclude the very people we say we're protecting, such as immigrants.
Anything else to add, Ms. Lepsak?
Yes, I would like to know why Mr. Iglesias and Rachel Langston have blocked me on emails. I'm trying to understand that.
Okay.
Can they answer that question? Because I mean, this is a democratic process, is it not? And I represent a lot of people.
Okay. Well, thank you for your comments. We're open to the next public comment if there's any.
So they won't tell me, Mr. Iglesias won't answer that question? Why I was blocked on his email?
I'm
When
sorry,
I was respectful?
Ms. Lepsak, this is not related to the agenda item. I thank you for your comments. So we're going to move on to the next public comment. Thank you.
We have Mr. Bruce Wolf. And your There you go. I think.
Okay, thank you very much. And understanding how this all works, any questions I put forward, I don't expect a response from you. They'd be purely a rhetorical at this point, which you can answer on your own or not. My comment is with regards to the context of the previous commenter. When making policy or amendments, it's incredibly important to take comments like that, where there's no safe harbor created in the work that you're doing. It's incredibly to take comments like that seriously, and to provide a response that is, that you're not going to provide any advice or anything. It's not really where you're at right now. Where you're creating amendments and recommendations, so it demands taking some input from stakeholders that will affect them in the course of their regular business. And it's essential for you that if it raises any flags or any red flags for you, to interpret what those are and to make the adjustments appropriately. Now, I've listened to you now for several hours, and you do that. You have that back and forth. I get that. I appreciate that. But I think hearing what was happening here, I feel like for myself and the work that I do, I would seriously be backed up into a corner. And if that is not raising red flags for you, hearing that from the public now, while you're making and deliberating just on the recommendations for amendments, that's very concerning to me. And I would appreciate if maybe you can make some notation or comment about that when those kinds of comments come up. Thank you very much.
Thank you, Mr. Wolf. Yes, public comment?
There's not appeared to be any further public comment.
Okay. All right, as I understand it, go ahead, Councilmember Walensky.
I just want to thank the commentators who have just provided comment. We do consider all of the comments, and we do respond to the comments in the course of the rulemaking process. And we are best equipped to respond to the comments when we can take them in and then go back to the subcommittee and do additional research and discussion. And then we will respond to comments in the formal rulemaking process. And so where we are today is just discussing whether to start the rulemaking process, but there will be, if it moves forward, there will be additional opportunities for public comment. And so we do appreciate all the comments and are considering all of them.
Thank you, Councilman Walensky. So what we have is potential to move forward with the modified text as proposed. This was commence the formal rulemaking process with a 45-day public comment period. And as Councilman Walensky said, there will be multiple opportunities to provide comment and feedback as this process moves forward, if in fact the council decides to move forward with the current text as modified. So want to see if we have a motion on that item. Councilmember Shuri, you have a question?
Yeah, I'm just wondering, in light of the numerous concerns that were raised today by the council, if the committee prefers to go back and do another draft before putting it into rulemaking, or if they want to proceed. I think there's two alternatives here, so.
Just speaking for myself, I would rather proceed. I think the comments have been very thoughtful, and certainly, we can think them through and see whether there's any way to what can and cannot be incorporated. But I think opening it up to the public for public comment would be really helpful.
Well, with that, then I would move.
Do we have a second?
I'll second.
Okay. Can we take a roll call, please?
Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong,
Aye.
Councilmember Iglesias,
Aye.
Councilmember Olude,
Aye.
Councilmember Scher,
Aye.
Councilmember Walensky.
Aye.
Great. Okay.
Thanks
so
very much. And I have lots of notes here, and I'm sure Julie does too. So we will you know, greatly appreciate your input.
thank you, council members. Okay, we're moving on to the next agenda item.
So I just have another question. I'm sorry. So this means that when it comes back to the rulemaking process in the current form, we need to make these same comments again to put them on the record.
I think so.
Okay.
And there will be opportunity to do that next. I don't know when the next council meeting is going to be scheduled. And of course, individuals who have feedback, including those who provided public comments today, can do that as well formally. Councilmember Hong, do you have a question?
I think though, in terms of process, we also discussed, if you have your written down notes, you can also submit them, right?
Is that an acceptable? I think I'm in supportive of that. I'm not certain if Rachel or Adam are we
I've done that before. Yes, I think I submitted written comments. And it became once the set was opened up for public comment.
So that's another opportunity that can be given to council members. I know Councilmember Brodsky, you actually presented as well in the past.
Yes.
As a member of the public, as it were. Okay. Councilmember Hong, you have another comment or question?
No, I think, I'm just since, right, I'm still relatively new to this whole process. I'm just trying to get a rhythm of like, right, how do we convey our notes on a process that needs to be transparent, but also can feel very painful in real time in terms of the edit. So I'm just trying to get a rhythm, like, right, should I just put things in notes, and so that way we have a record of it. And so part of me is just processing out loud, but also understanding that this is a first set of, I think, multiple items that we'll be presenting in the next year, just so that I have my own set of systems moving forward.
So as I understand it, there's different ways to provide feedback. The ones that you articulated, Councilmember Hong, I think that's acceptable, and it would alleviate some of the issues that we find ourselves sometimes addressing different elements during the meetings of particular proposed texts. So I find that encouraging that we should do that if we can. Okay. All right. Anything else? Councilmember Walensky?
Just a procedural clarification as to what Councilmember Hong is asking about. So if council members want to submit comments in writing to the subcommittee, would it be appropriate to email that to the FEH council address during the public comment period and have that then that would become part of the rulemaking record, the same as any other public comments? Is that correct? Can the department confirm that?
Yes, that would be very helpful and work well.
Thank you, Councilmember Walensky. Anything else from council members? Okay, so we're moving on to consideration of proposed changes without regulatory effect. Item number 11, related to the implementation of the department name change, addition to designated person to the California Family Rights Act, and addition of reproductive health decision-making as a protected characteristic under FEHA. Deputy Director Adam Romero, go ahead.
Good afternoon. This is a proposal from the department to implement 3 statutory changes, 3 statutes, 1 that already went into effect and 2 that are going into effect on January 1st. The first is SB 189, which you all know changed the name of our department to the Civil Rights Department and changed the name of the council to the Civil Rights Council. And so we've done a sweep through the council's regulations to make changes to the council's name and the department's name to reflect our current names. In addition, in 2022, the legislature passed and Governor Newsom signed AB 1041, which amends the California Family Rights Act to add a new designated person that an employee can take leave for if eligible for CFR leave. In addition, the legislature passed and Governor Newsom signed SB 523, which adds a new protected characteristic to the FEHA's employment provision. And that protected characteristic is, quote, reproductive health decision-making. And so what we've proposed here, you'll remember from last year, and if you were on the council before that in 2020, changes without regulatory effect. This is essentially an express route to update the regulations where the council has not exercised any discretion, but instead is moving to implement statutory change or make other non-substantive changes. And so that's what you see in this package. And with that, I'm happy to take any questions, but I think it's pretty straightforward.
Councilmember Iglesias?
Yes, thanks. The content of this all looks totally fine to me and good. And I guess the question I have, which goes to the conversation we'll have eventually about workload and balancing, is whether or not the new law that creates as a new category reproductive health decision-making, whether that new term is going to or should require some regulations to flesh it out. I could imagine there could be a number of different complications about what constitutes health decision-making, and all that stuff. So I just raised that for a future discussion about whether or not there ought to be yet another subcommittee created to consider whether some regulations need to be drafted to implement and clarify that. So that's just my thought.
Thank you.
Councilmember Sure.
I think these look great, and I appreciate all the work that went into them. And one of the things I loved about being in council is I learned about new laws that I missed, and several of these changes are really good ones I hadn't heard about. So it's great.
Thank you for your comment, Councilmember. Anybody else? Okay, do we have any public comment, Rachel?
No, we do not have any public comment on this matter.
Okay, thank you, Adam. Move forward with the motion. Do we have a motion?
I move.
Okay.
Honk.
Anybody second?
Second.
Great. Roll call, please.
Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Olude.
Aye.
Councilmember Sure.
Aye.
Councilmember Walensky.
Aye.
Thank you very much. We will transmit these to the Office of Administrative Law.
Thank you, Adam. Much appreciated. All right, next agenda item, we have an update from the Reasonable Accommodations for Associational Disability Subcommittee. Council members Dale Brodsky and Adetunji Alude.
Thank you, Chair Sandoval. The potential for regulation on reasonable accommodations for associational disabilities is still under review by the administration, and the subcommittee continues to research and respond to inquiries from the administration. But in keeping with a lot of the new employment laws set to take effect at or around the beginning of this year, the subcommittee would like to broaden our mandate. There was some discussion about sort of reassessments of subcommittee mandates to address other topics related to family and medical leave, including potential regulation on the California Family Rights Act, pregnancy disability leave, and changes to bereavement leave related to the passage of AB 1949.
Thank you, Councilmember.
And I think we need your direction and approval to do that. So
Expand the scope.
can we make a motion to expand our coverage to include those areas.
So moved. Do we have a second?
Second.
Okay, roll call.
Sorry, I apologize. I was just double checking something. Okay. uh, Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Olude.
Aye.
Councilmember Scher.
Aye.
Councilmember Walensky.
Aye.
Do we have any comment by our council members regarding
Thank you very much.
any public comment?
There's no public comment.
Okay. All right, next on the agenda, we have update from the Criminal History and Employment Regulation Subcommittee. I have nothing to add other than what was done today. Councilmember Walensky, do you have anything else to add?
I do not.
Council members, anything to add on this item? Okay, seeing none. Any public comment, Rachel, on this item?
There's no public comment on this item.
Thank you, Rachel. All right, we're moving on to the next agenda item, update from Government Code Section 1135, the Regulation Subcommittee. Council members Dale Brodsky and Dara Shore. Go ahead, Councilman Shore.
Yeah, that's going to be me. I am happy to report. We've had some movement on the regs, which is great. People may recall we developed a set of regulations, very extensive regulations, updating the regulations, which hadn't been updated in a number of decades, I think since they were first drafted, in light of a variety of statutory changes and updates. And regulations go through a two-step review process through the administration and then through the Office of Administrative Law. And I'm happy to report that we will now be, and we now anticipate that we'll be ready to submit the package to OAL in January or February, and they have a 30-day review process. So we are hopeful that these regulations will go out for public comment in the first quarter of next year, which is really amazing progress. So we're very excited about that.
They are proposed regulations. They are not regulations yet.
Proposed regulations out for public comment. Thank you for clarifying.
We're very excited. We've been working on them for a very long time.
Well, thank you, Councilmember Shore and Brodsky, for all your hard work on this item over the year. Any comments from other council members?
Just congratulations. Great to see it moving forward.
Anyone else? Okay, so let's move forward to the public comment. Any public comments?
There's no public comment.
Okay. So next on the agenda is update from the Hate Violence Subcommittee. Councilman Brodsky, do you want to speak on this or? Okay. So Councilman Brodsky and I have been meeting with different individual stakeholders, but first and foremost, I'd like to say we've been working with Becky Monroe and kind of thinking through how we could better assist the efforts that are currently underway. We know that there is lots of opportunity that was already identified by not only Becky Monroe, but by Lily Harvey related to how we could address issues of hate incidents and hate violence, given our role here on the council. So what we're doing is we're fleshing out a little bit once the California versus Hate Hotline and Network is in full swing. We are going to be part of a collaboration with Becky and others to see how we could be more effective in rolling that out, hopefully. We also are looking at any type of additional ideas that we can get from stakeholders. I personally, and maybe in concert with Dale Brodsky and others, I am going to take the opportunity to meet with individuals who are here in Southern California including Matthew Barragan, who I know from MALDEF days, who's now heading up the effort from the U.S. Attorney's Office, as well as the head of LA versus Hate. And also I met an individual who's a vice president or the chairperson of the State on Hate Commission, Bambi Salcedo, who I was introduced to a few days ago. I'll be meeting also with that commissioner in the next few days to just identify ways that we could work more collaboratively. So this is an evolving effort because there's lots of new individuals and energies that are being focused on this. But as you know, we had a hearing on issues of hate incidents and hate violence a couple of years back now. We also issued a letter to different entities throughout the state of California, reminding what Becky Monroe mentioned, that if in fact an incident does not rise to the level of a crime, it still could be addressed in other ways through civil rights enforcement and the like. So that's where we are at this stage. We're looking for ways to collaborate also with Lily Harvey and how this might be important for our role as individual council members, which we'll address in another subcommittee report out moving forward. But Dale Brodsky, do we miss anything? Anything else you'd like to add?
I think you nailed it. Yeah.
Okay.
Thank you.
Any comments from council members? Any thoughts, input, inquiries? All right. Any public comments?
There's no public comment.
Okay. Thank you, everyone. We're moving next to update from the Algorithms and Bias Hearing Subcommittee. That's council members Tim Iglesias and Helen Hong.
Thank you very much. So we are at the stage of continuing to consider comments that were made in the last public hearing in preparation for hopefully giving to the council in our next meeting a set of regulations to hopefully move into, or proposed regulations to hopefully move into a rulemaking process. I think that's correct. Anything to add, Helen?
So I would just encourage, it will be a pretty intense package. And so I would highly recommend if council members would put their comments in paper and submit them, it will be extremely helpful. You guys gave a lot of really great feedback at our last meeting, but since this is so nuanced and it's we are clarifying, I think that'll save both staff along with us a lot of time, but also fully capture all your expertise and your perspective. So I would really encourage you, as when you get it, to either put it into a Word or into the Adobe and put your comments in so that we can really capture as we move the best product forward.
So should that be as part in the public comment phase or before the public comment phase?
May I just clarify the where we are procedurally? So in August, the council actually voted to move the proposed regulations forward into rulemaking. The subcommittee and the department, upon further reflection of the comments that were provided in August, decided to continue to refine the proposed regulations. And so that's what will be, rather than starting the formal rulemaking process now, the subcommittee will be coming back with a new proposed text for further consideration before we initiate the 1-year rulemaking process.
Do you want council comments in writing before it gets submitted, before you bring it to the group for vote, or after?
After. I mean, we can't, right? So it's going to be the same time, but ultimately it's kind of what we just did today. You'll put your comments and then we'll incorporate it along with everyone else's public comments. And just so that you're not duplicating our work twice, I'm sure you're going to always give your keen eye and input. And so as you do that, maybe then hold off until the next, once it's published, and then we'll reincorporate it back.
Okay, yeah, that's what I was thinking, because it would have to, before we could submit them to you in writing, they'd have to be put into public comment. Okay.
Sorry.
But before we move them into rulemaking, we have an opportunity to comment on them again. So and we usually do that orally. We don't usually do that by written comments, but there's no reason, I believe, why once they get published with the agenda, we couldn't submit them in writing to the department for consideration by the council. Is that right?
I think you can do that. It won't be formally considered as public comment until the next phase, but it does, I think, provide a vehicle to help the authors or those in the subcommittee to get your input prior to the committee meeting or at the council meeting. Adam, do you agree?
It can be helpful, but I think Councilmember Schur is right that before the formal rulemaking starts, the council has not historically, council members have not historically provided written comments. And so the next stage at the next meeting in January or February, whenever that happens, it'll be similar to the religious accommodations package that was discussed today. That will be the status of these regulations. And then the council will have the opportunity to vote again on a proposed text to move into formal rulemaking if the council would like to do that.
But it is acceptable for council members to provide written comments in anticipation of the meeting, even though they're not going to be part of the formal public record. Is that right?
That is right. They would not be part of the formal rulemaking package because
Right.
the rulemaking has not yet been initiated.
Can't be loose.
And I'm not sure that we could circulate though prior to the meeting because of, I don't know that we could share with the committee other council members' feedback prior to the meeting.
No, I don't mean prior to the meeting. I mean, once we have the 10-day rule, right? Like, once it's up, everyone has comments, and I feel like we go through the same process.
I think we'd have to discuss them publicly at the meeting before,
I think so.
before we could share them. Like if Dale were to, sorry, I think if somebody can.
Yeah, I think
updated me. You've been assessed at 70% disability.
I think it's
Oh, sorry.
80.
Here we go. Hang on, I got it.
Uh-huh.
Okay, there we go. Okay, sorry, so I guess what I'm saying procedurally is that I think, you know, if, for instance, if Councilmember Brodsky were to send comments to the council listserv, I don't believe I could share those comments with Councilmember Hong and Councilmember Iglesias prior to the meeting, because that in essence would be a third, you know, 3 communications, but maybe I'm thinking about.
So even if that is the case, I think I'm thinking, and Councilmember Hong, it would be helpful to have that, even if they cannot incorporate prior, it'll be helpful to have it for the meeting so that we don't have to go every single item. And Councilmember Schur says one thing, Councilmember Walensky says another thing. Everybody will have what their issues are and concerns are, so it's easier to digest when we have a formal council meeting. Is that something that's acceptable and possible to do? Any concerns related to that?
So if I could just take a step back, I think part of it is that when council members review the documents, they have thoughts and they give us the input. If we do say that we need to go back again, then we will go back again. If not, we can incorporate that during the public comment. But in order to save their time, instead of verbally doing it and then sending us into writing just to do it in writing, they can give it to us the day of when it's the same time that everyone's getting it. That's fine. Or if it's not during the same time, afterwards. I'm just trying to decrease the amount of you know what I mean? Trying to save time as well as getting the materials in writing, as opposed to doing everything verbally when there's so many commenters and it's good material, it's substantive, and it's difficult to capture it, particularly in the public rulemaking process.
Councilmember Schur?
I think we do have to make a distinction between the 45 and 15-day comment periods in which we can submit comments just like any member of the public, and the period at which we're just having discussions at the meeting. And the problem is not that I mind putting them in writing, but we still have to read them orally because it's the only way for everybody on the council to hear what they are, to determine if you want to make changes during the meeting in order to move the package. So what happens is we have these discussions, and then if they're simple changes, people make them during the meeting, and we can then move the package into rulemaking. Even if they're complex, sometimes we do it, but submitting them in writing may help us read them back into the record clearly, but it's not like you're going to have them in advance of the meeting. So we would still need to read them orally into the record.
That's great. I think what I need is also in writing. I tend to be more visual, and so it makes it really difficult for me to process what you're saying and to follow up after the fact. So maybe I need to clarify that. I don't expect us to shortcut it. I think though I'm not fully capturing everything that you're saying when it's just verbal, and then after the fact, I'd like to see how to go back to it. Just like when we get public comments from the public, we get them in writing, and so it's so much easier to then review.
Well, we get them in writing during the official public comment periods. We don't get them in writing at this stage. Now, I don't mind trying to do that, and then we could share the screens with everybody, I suppose, to go through them on some of them if that's helpful. That is, I think, possible to do. But it's still going to be at this stage where you're trying to decide whether to move it into rulemaking. Either you just take note of it in your head and you deal with it in the later process, or if it's people have serious concerns and don't want to move it into rulemaking, you have to make the changes at the meeting based on the comment at the meeting. So if you're, I don't have a problem, at least that's my understanding, having been on the council for a long time, but I'm happy to try and put written versions of them up if that makes sense. But
well, members of the public can submit things in writing before the meeting, before the public comment period. It's just that they have to resubmit them in order for them to become part of the actual public record. The comment.
And I'll just add I think the animating concern here, Councilmember Hong, is not to violate the Bagley-Keene Open Meetings Act, which prohibits 3 or more council members from meeting outside of a noticed public meeting. And so we just need to be careful not to in any way violate that act.
Fully understood, and I fully appreciate that. And then maybe it's not like I needed before, but maybe during and or after is my goal, right? Just having it so that I fully incorporate people's comments. And so
I think, yeah, I agree with Councilmember Hong, and I understand the concern you raised, Adam. I don't know if you want to check in if that, except I do think that people absorb information different ways, and it would be good to have something in writing with all the other issues that have been raised addressed, right? So that we're not violating any kind of act or anything of that sort. But and even, for those who want to, right, instead of repeating what their concerns are, just putting it up on the screen, and then that could be submitted and reviewed by the council members who are charged with this responsibility. But
I'd recommend the department look at some other public bodies to see if there's some strategies that we can suggest to visually and more effectively share in the public the different feedback from council members. So let us research that and make some recommendations.
I'll just say in the meantime, I take really good notes. So and I will go back and watch pertinent parts of the video to make sure I capture all the public comment and council comment. So Helen, I can be kind of a backup in that way.
I totally appreciate that, Rachel, but it's a lot for you to have in your in your mind and in terms of time. And so just understanding how long this process is, I just want to make sure that I'm refreshing my memory, and I tend to be much more visual. And so and just like when Tim was talking about all the items in the criminal history, I mean, I glazed over after minute 3. And so I know that we're going to be it'll be more than 30 minutes for us, right? And so I'm just trying to anticipate how do we incorporate all that in a way that I want to be responsive.
Thank you, Adam, for your offer to check in to see if other agencies do it in a way that addresses issues raised by Councilmember Hong. And I see that Councilmember Schur has her hand raised. Go ahead, Councilmember Schur.
I'm happy to try and do this if we figure out a way to do it, even though it's substantially more work. But I would say that it shouldn't be mandatory, because some comments really are discussion items. They're not easily put in writing.
Yeah,
so
I'm sorry.
Voluntary.
Yeah, I'm sorry. I didn't make it optional. And if that's your normal way, that's what I do, right? I normally put all my notes and comments in real time, and so otherwise I won't remember it. And so yes, If it is, that'd be great. If not, it's not something that I'm trying to change in terms of requirements.
And how long again is it that the recording of our meeting is posted after we meet?
There's no set date, but it's as soon as possible, so.
Okay. Anything else on this item from council members? Any public comment?
We do have one public comment from Bruce Wolf. He states that substantive changes that are not agendized for action must be continued to the next meeting for action.
Okay, anything else? Thank you, Mr. Wolf. Okay, so we're going to move on to the next item. Update from Housing Regulations Review Subcommittee. Council members Dara Schur and Tim Iglesias.
Want me to go, Tim, or do you want to? Go ahead.
You go ahead, please.
Well, it's more good news. We have another set of housing regs. People may remember this, that they approved to move into rulemaking, and they've been through the first administrative step, and staff intends to submit them to OIL sometime in the next, hopefully before the end of the year or early in January, and then there's a 30-day response period before they go out. So they should go out for public comment in January or February, before the next meeting. They should go out before our next meeting, so we have a chance to discuss them at the next meeting in the formal rulemaking process. Remember, these are just mostly cleanup changes, not major substantive changes, but they will move forward. So thank you, and thank you to staff on both sets of regs for all the incredible work they've done.
Thank you, council member. Anything else, Councilmember Iglesias? Okay. Any comments from council members, other council members? Any public comment?
No, there's no public comment. There's one that I'm responding to that's technical, but other than that, there's no public comment.
All right, next up, we have update from the UNRU Act Subcommittee with council members Adetunji Alude and Julie Walensky. Go ahead.
The subcommittee is still exploring possible changes and sort of scope of changes to the UNRU Act. But the subcommittee has conducted some stakeholder outreach as well as research on possible regulation to the Act. And the subcommittee is very happy to hear that we'll be moving forward with 11135 and interested in reviewing those changes when they're available to determine if changes made there may be applicable to updates to UNRU.
Thank you, council member. Any other comments from other council members? Any public comment?
There is no public comment.
Okay, all right. Thank you. So we're moving on to the next item, update from the Community Education Outreach Subcommittee. Councilmember Hong?
Yes, so Chair Sandoval and I have met with Lily and Adam. What we're trying to do is provide input as they're developing their strategic plan and understanding what interests and roles and opportunities the council has to support and engage the work for outreach and engagement with community. What we really want to be cognizant of is that we're not trying to create new work, but also understand that with the regulatory process, there are opportunities for council members to bring in their areas of expertise and contacts. And so some of this could be, some of you are really interested in doing webinars and sharing your expertise with these new regs that may have been implemented, or areas that you have just substantive expertise in that would be great in terms of community education. And so we are working with Lily to gauge where we might align and what role we can be in terms of support and also play a key role in. I think one area that we'd love to hear from council members are like, do you guys, not everyone has to, but if you do have an interest in education, providing webinars, making key introductions to areas that we may find that we have gaps in, or interested in even just engaging in different communities and community members to find out what is happening within different communities that we may not be aware of. That's what we're trying to gauge. Chair Sandoval, is there anything else that I'm missing?
No, that's pretty much covers our initial kind of request of our council members to see if they are interested in participating in this way and assisting Lily in expanding outreach and community education. And again, there's lots of needs, lots of requests are coming into the Civil Rights Department. And I know that all of us have in some way, shape or form provided this type of service either on the council or in our other jobs or responsibilities. So it would be incredibly helpful if those who are interested to participate in this way, again, through webinars, convenings dealing with civil rights compliance in different regions, serving as a guest speaker to speak on issues you feel comfortable speaking on, including general issues that may come up related to the Civil Rights Department and their enforcement as kind of a general education to different stakeholders. And this includes from business entities to civil rights organizations, to educational institutions and other stakeholders throughout the state, either in person or via video conference. So that is the initial request and hope regarding this particular item. Councilmember Iglesias, do you have a comment or thought?
Yeah, thanks. And thanks for doing this work. I know it's challenging. I definitely would be interested in being part of the outreach. And in particular, I know that there was discussion a long time ago about outreach to other civil rights organizations, and particularly local government civil rights organizations or human rights that are kind of established in local governments. And I would certainly be interested in being part of outreach to those groups.
Right, and you're speaking of like the human rights and civil rights departments of municipalities, localities in your area? Okay, thank you.
Exactly.
Great. In terms of a process, Lily, is there a way that our council members can send you an email identifying, or maybe you could send us a template of what you're looking for in terms of areas, regions in which we would be willing to assist, topics, those kinds of things, understanding that this is voluntary.
Yes, the short answer is yes. I'm happy to send a template out that'll identify some of those key questions so we can get a better sense of availability, interest, issue areas, geographies, in-person webinar, all those details. I'm happy to do that. Thank you so much.
Thank you so much. Any other comments from other council members? Okay. So Lily, should we expect communication from you sometime later this week or early next week regarding the same?
Exactly that. Yes, hopefully end of this week.
Okay, thank you.
Thank you.
All right. Any other comments from council members? Okay, do we have any public comments on this item?
Yes, we have a public comment from Brenda Lebsack. So I am unmuting at this time.
Let's go ahead.
Yeah, thank you. Rachel, you could just answer my questions in my chat if you'd like. I was just asking a little bit of more information on how the members are chosen. Are you elected? Are you appointed? I'm not familiar. And also the qualifications to become a council member for this California Civil Rights. Or you can just send me a link if you'd like so I can get those answers.
Sure, just as a general matter, we're gubernatorial appointees, and Rachel can send you a link to particular regulations with regard to our duties and responsibilities. That I think would answer your questions.
That would be great. I do have one more question.
Go ahead.
Okay, so back in July of 2017, because I did read the hearing of when you changed the definition for gender identity. And my understanding is the two main influencers in that change, as I read it, was the Transgender Law Center and the equality of California. Oh, I forgot the other group. There's another group. And it just slipped my mind. But Transgender Law Center was one of them, and the other one was a special interest group. So it was those two groups. Am I missing anything here? I know that the ACLU piped in and did comment. I don't know if anybody can remember back when that definition was changed and how it was changed and the influencers involved in the change of that definition. Does that ring a bell? Equality California and Transgender Law Center. Those were the two special interest groups that influenced that decision.
Ms. Lepsak, I was not on the council back then, but I believe that that information can be found in the legislative history regarding the protections afforded to individuals based on gender identity. Thank you for your comment. Any other comments? Rachel, any other public comments?
There are no further public comments.
Councilmember Iglesias, you have your hand up on this issue? No, okay. All right. Anything else to add at this time? All right, well, thank you everyone for participating. I'd like to thank the public for participating in today's council meeting, Civil Rights Council meeting. I also like to thank my fellow council members for your work on all the regulatory and non-regulatory matters. And of course, I'd like to thank our colleagues from the Civil Rights Department for all the work you're doing day in and day out to promote civil rights in our state. Thank you, everyone. This meeting is adjourned at 5:02 p.m. Take care. Bye-bye.
Thank you. Happy holidays.
Thank you.